And please, Your Lordship, I beg to mention for listing. Obliged.
Yes, Lordship. I beg to mention item number 14.
14. One adjournment.
Adjournment.
Why?
Senior counsel is out of station for medical treatment.
Your name?
R. Shah.
R. Saha, petitioner.
Item 1 for motion.
Matter, my lord,
Yes, Mr. Pai.
yes, my lord, this matter, my lord, I have talked to the learned, my lord, the tribunal member, as well as I have also gone through, my lord. There are some.
This item 1.
Yes, my lord, there are some.
Did you pass any order?
No order has been passed, my lord.
Instruction was sought for
Instruction was so spoke. Your lordship may remand or your lordship.
No. Why what kind of instruction we
My
want?
lord, in page 15, my lord, the learned tribunal actually did not consider the 1971 voter list, my lord.
Page 15.
15. No? The voter list of 1971 as well as the, my lord, the.
Page 15. There is no page 15.
15, my lord.
Then what is this? Last page is page 12. What is this?
Opinion is there, my lord.
Oh, it's additional.
Opinion
The
is-
running
Page 14 starts.
page 14. Sorry.
Page 15, my lord, last.
Hmm.
The petitioner, my lord, submitted the voter list of 1971 and citizenship certificate, my lord. The tribunal outwardly rejected those documents, my lord, and said that those were not proof.
Not
that's
true.
Yes, my lord.
But
That's why
these
your-
are, I think these are certified copies.
Yes,
Certified copy of the voters.
your lordship. That's why, my lord.
Certified copies did not be
Not
proved.
this, not
Section
this.
65 or 63,
Yes.
76 and something of the 78 of the Evidence Act. These three sections read together, it did not be proved.
Yes.
Lordship, the person herself has casted vote, she has migrated. So if again,
If her name appeared in 71
yes, and
and-
certificate of
and this
registration.
petitioner and that person is the same person,
Yes,
that
Lordship.
itself is good
Yes,
enough.
Lordship.
Why should we send it back?
Yes,
Why not
Lordship.
finish it here only?
As your
Yes,
lordship, I have. no-
Because there's nothing to prove. Only
Yes,
thing,
sir.
do you doubt that that man and this
This
petitioner, they are the same person? Do you doubt? Do you sincerely doubt?
My lord,
Not casually doubt, for the sake of doubting.
that is,
Do you sincerely doubt or it is the same person? We do one thing. We'll declare the person, but we'll also allow you to make inquiry. If you find that that person and this person is not same, you are free to file a review before the court.
obliged.
But otherwise, why keep on troubling these people? That is also a
No issue, my lord.
difficult proposition, going to the court every day, every day. Heard MSD Ghosh Land Counsel for the petitioner, also heard Mr. J. Pine Land Counsel for the sovereignty view. Okay. The petitioner Josna Rani Dr. alias Josna Rani Dr. Purokayster had been referred to the Foreigners Tribunal number
Two, Lordship.
2 Nagaon for rendering an opinion as to whether she is a person who entered the state of Assam from the specified territory on or after 25/3/1971. Yes, that young lady who accompanied you yesterday. This is the question we are determining. Therefore, we did not intend to accept what you were submitting. This is the only question it is determined. So this is not a writ proceeding where somebody is claiming right as a stateless person. That's what we are required to do. Here we are determining whether what kind of declaration the tribunal had made, and under the law, what declaration they can make. If you want a change in the law, you file separate petition for the same argument. Whether the entrepreneur specified territory. The tribunal passed an order dated 17/4/2018 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies upon a voters list of which page, Madam Ghosh?
Lordship, I have marked flag mark, yellow flag mark.
Uh,
Because registry has not.
Relies upon a voters list of 1971 of village, what's the name of the village?
Ward number.
Village
No.
ward number 10
Nagaon.
of Nagar town, which contains the name of Josna Rani, wife of
Preeti doctor.
Preeti Datta. He is the husband. Preeti Datta is the
Yes,
husband of
yes.
Preeti Datta at serial 1152, and that of Preeti Datta Purakaista at serial 1151. And both are shown to be residing in the same house number 83. The petitioner claims that Josna Rani, wife of Preeti Datta, at serial 1152 of the voters list of 1971 is the petitioner herself. No credible material is available before the court that the writ petitioner proceeded Josna Rani Datta Ni Purakaista, NEE, Ni Purakaista, is not Josna Rani, wife of Preeti Datta, of the voters list of 1971. The voters list of 1971 is the photocopy of a certified copy of a voters list duly issued by the competent authority. Evidence Act on sound. But the original is available in record, original of the certified copy.
It will be there in the record.
Okay.
I'll just check.
But at the same time, the original certified copy is also available on record, which has been perused by the court. A certified copy is governed by the provisions of section 63, '76 and 79 of the Indian Evidence Act 1872. Section 63 provides that secondary evidence means and includes certified copies given under the provisions contained therein. Section 76 provides the procedure by which a certified copy may be issued by a public officer having the custody of a public document. It is noticed that a certified copy had been issued under the signature of the electoral officer, and it is stated that the electoral officer is a public officer and is the custodian of the original voters list. It is also noticed that a requisite stamp dues as required under section 76 had also been paid by the petitioner for procuring this certified copy. Section 79 of the Indian Evidence Act 1872 provides that the court shall presume to be genuine every document purporting to be a certificate, certified copy, or other document which by law declared to be admissible and as evidence of any particular fact, and which purports to be duly certified by an officer of the central government or the state government or by any officer in the or government, etc., who is duly authorized thereto for the purpose. As in the instant case, the certified copy of the voters list of 1971 had been issued by an official who is duly authorized under the law to issue the certified copy, we are of the view that there is no further requirement of the proceeding to prove the contents of the certified copy of the voters list of 1971. It is noticed that in the order impugned of the tribunal dated
Dated
The dated so and so. The certified copy of the voters list of 1971
17.
of ward number 10 of Nagaon town had been rejected by the tribunal on the ground that the petitioner had failed to prove through any other cogent evidence as regards the contents of the certified copy. Full stop. As already concluded, comma, as already concluded, comma, as under the provisions of the Indian Evidence Act 1872, as indicated above, there is a presumption under the law as regards the genuinity of the contents of a certified copy. Once the certified copy had been duly issued by following the procedure of law laid down in the Evidence Act itself, comma, there is no requirement to prove the contents thereof. We are of the view that the tribunal had misdirected itself in rejecting the citizenship of the petitioner by not accepting the certified copy of the voters list of 1971 of ward number 10, Nagaon town. If the name of the petitioner appears in the voters list of 1971 of ward number 10 along with her husband, comma, it can be safely accepted that the petitioner cannot be a person who had entered the state of Assam from the specified territory on or after 25/3/1971. As already indicated about, no material is also available on record that the writ petitioner proceeding and Josna Rani, wife of Priti Dutta of serial 1152 of the voters list of 1971 of ward number 10 Nagaon are not the one and the same person. In view of the above, on being satisfied upon the burden being discharged by the petitioner under Section 9 of the Foreigners Act 1946, we declare the petitioner Josna Rani Dutta Ni Purokayasta to be a citizen of India, and also that should be entitled to all such rights and liberties as may be entitled under the law. However, we leave it open to the respondents in the Home Department of the Government of Assam to make their own verification, and if it is found that the writ petitioner proceeded Josna Rani Omogomo and Josna Rani, wife of Priti Dutta, at serial 1152 of the voters list of 1971 of ward number 10 Nagaon are not one and the same person, the respondents will be at liberty to bring it to the notice of the court in any appropriate form.
Lordship, it's a compared copy, compared with the original. We have checked the records. It's approved in original.
That's what that means. You
Yes,
must have produced.
yes, and then taken.
That is the available in record original. The original of the certified copy had been produced before the tribunal, and there is an endorsement of the tribunal that it had been proved in original.
Item 2.
May please, Lordship.
Yes.
Item page 17, my lord, 17. Voters of 1966,
Hossein Ali grandfather.
grandfather. Then, my lord, kindly see page 25, my lord. Page 25.
Page 25.
A. Kudus, my lord, son of Hossein Ali of village Titapani.
Page 25 is Titapani.
Yes.
There is no name here.
Next page, my lord.
26. Kudus, son of Hossein Ali.
Kudus,
What is
son of-
Titapani? Other one is also Titapani.
Yes.
Yes, then
And Hossein Ali Edius, my lord, page 59, my lord.
59. What is 59? Editor in chief DW2 Kudus.
Yes.
Kudus of Titapani.
Yes. my lord. Yes,
And was he cross-examined?
No, my lord. Only question for asked by the court.
Fine. What to do? Go back and you cross it. Otherwise, it's an admitted evidence. Heard Mr. H.R. Ahmed, Law and Counsel for the petitioner, also heard. Hmm? Huh? The petitioner Kulsum, only Kulsum, there is no
Yes.
other name,
My lord,
only one word.
my lord.
The petitioner Kulsum was referred to the Foreigners Tribunal number.
Page
Where is,
67.
which page? 60?
67, my lord.
67. Was referred to the Foreigners Tribunal number 5, Borpeta, for an hearing opinion as to whether she is the person who entered the state of Assam on or after 25/3/1971 from the specified territory, resulting in registration of FT 5th of case number FT 5th 47/16. The tribunal rendered an opinion dated 10/9/2018, declaring the petitioner to be a foreigner. Being aggrieved, the state petition is instituted. Mr. Pine, we wanted to see some sample copies of the
Yes.
orders where they are declared to be citizen.
Yes, I asked my lord them to,
It has not yet come.
yes.
Ask them to send it immediately. Because if some of the methods used to declare to be foreigner, if the same methods are used to declare to be citizen, then that also may be wrong. Without going to the core aspect,
That
if
is
you
true.
just on some peripheral issue, if you declare somebody, that will also be dangerous. Being aggrieved, being aggrieved is in the writ proceeding, the petitioner relies on the voters list of 1966 of village Titapani, police station Bagbor in the present Borpeta district, which contains the name of Hussein Ali, son of Sahib, at serial 233, and that of Kairan Nessa, wife of Hussein, at serial 234, and both are shown to be residing in the same house number 90. Reference is also made to the voters list of 1989 of village Titapani, which contains the name of A. Kuddus, son of Hussein Ali, at serial 565, and that of Maiful Nessa, wife of A. Kuddus, at serial 566. It is claimed that A. Kuddus of the 1989 voters list of village Titapani is the father of the petitioner. To establish that A. Kuddus of the 89 voters list of Titapani is the father, Kuddus, A. Kuddus, son of Hussein of Titapani, had deposed before the tribunal as DW2, wherein he takes a specific stand that the petitioner Kulsum is his daughter. But it is noticed that DW2 had not been cross-examined by the Home Department of the Government of Assam. In view of the above, remanded back to the tribunal to enable the Home Department of the Government of Assam to cross-examine DW2 as regards the veracity of the deposition he had made in his examination in chief on affidavit. The Home Department may also make their own verification and submit a report before the tribunal. The petitioner may also produce any further material if so advised. Upon doing the needful, a reason order be passed.
Item 3,
July.
May I please your lordship? My lord, my humble prayer will be lordship. Mother has filed her evidence on affidavit, but she was not cross-examined. So if the matter is.
Same thing. Same as the last one.
Yes, lordship. Page 22, mother's evidence is there, lordship. Otherwise, mother has
Madam-
casted vote in 66. Yes, lordship.
As per the earlier order,
Yes.
can you give the particulars? The same language, same script will be there.
Yes, and she, if required. she
No.
will
Uh-huh.
more evidence.
No. Or do we have to dictate it separately, your order? Ultimately, it will be ad verbatim same, except for the
Yes,
Matter.
case number difference,
Yes.
tribunal will be different, the
Yes,
voters
Lordship.
list will be different,
yes,
and
lordship.
the name of the mother will be different.
Yes, lordship.
The rest will be all same.
Yes, lordship.
Give the particulars.
Yes, and additional evidence also if you. like.
Same.
Yes, Lordship. Yes,
Same order as the last item. Only
Yes, sir.
thing, the factual
Factual, I'll
particulars you
provide.
give it.
Deeply.
Pariban, right?
Fourth,
Or else you do one thing. Whenever you type it out, just give a draft to it. That will just change for you. Oh, yes.
Yes, Lordship.
Horidasi Mundal. Who is the father?
Father is Horendra Bepari.
Page number.
Page number 31, Lordship, father and mother.
Page number 31. Father and mother. Horendra Bepari. What is this? Certified copy or what? Mohuma Karjaloy
Yes.
Nirvasan.
And then 70 also is there.
No.
certified.
Who had issued this one? Nirvasan Panjiyan Bihaya. It's okay. Certified copy, no?
ভোটার তালিকার প্রমাণিত নকল।
একটু দিব না এগুলি করে আছে সেকশন আছে ডাইরেকশন তো দিব না এগুলো প্রশ্ন থেকে একটু সহ্য নীতি বলেছি সেক্রেটারি কারণে Fine, where is the provision providing for the power of the tribunal? Where is the provision providing for power of the tribunal?
Fairness Tribunal Order 1964.
Which provision?
I'll just get my. Procedure for disposing of.
Yes, Ms. Chakravarti, how are you? How are you? Good to see you after a long time.
Procedure for disposal of question.
Which one?
Fairness Tribunal Order 1960.
No, which section, which rule?
Rule 3, Lordship.
1964 order.
Yes, Lordship.
No, we have read it, but that is only the procedure. What the tribunal can do, what the tribunal cannot
Powers
do.
of Fairness Tribunal, Rule 4.
Rule 4, okay.
Powers of Tribunal.
Power is rule 4. No, this is the power means that the procedure under CPC, CRPC will be followed for certain purposes. Only that. What the tribunal can do and what the tribunal cannot do. Where is that power? Is it provided anywhere?
Procedure for disposal of question.
No, that's a procedure. Issue notice, this, that. If it doesn't appear, what will happen? Then ultimately what we will do. 4 says, for the purpose of the procedure, invoke the provisions of CPC, CRPC for the relevant specific purposes.
And 316 says the final.
What the tribunal can do and what the tribunal cannot do, is it available anywhere?
The procedure only is there.
The
The final order, Rule 316 says that the final order of the Fairness Tribunal shall contain its opinion on the question referred to which.
No, we have read it, but we have yet to locate any provision which will say what is the limit or to what is the power to be exercised, what it can do and what it cannot do. I think that is not there. Not there. Huh?
Why not 1964 rules? The only power given under section 2, my lord. Rule
Section
2.
3.
Rule 2, my lord.
Rule 2,
Two.
Constitution.
Yes,
The 1964 rules.
yes. ma'am. The central government may order refer a question as to whether a person is not a foreigner within the meaning of Foreigners Act 1946 to a tribunal to consider.
For its
This is the-
opinion.
Yes, ma'am. So
So
power,
this is the indication that it will give its opinion.
opinion only, ma'am.
Opinion as to whether a person is or is not a foreigner.
Is a foreigner or not foreigner? That must be. And there is no separate rules framed thereafter.
Nothing is there, I think.
Yes. It is guided by, my lord, some judgment of this honorable court.
So various time to time,
Yes,
whatever
time to
judgments
time.
are there.
And mainly, my lord, after Sarbananda Sunwal, my lord, the Muslim Mandal has come. So those are the principal guiding principles of the tribunal, my lord.
No, we are asking for a different purpose. What is opinion?
Otherwise, the power is only this much.
Opinion বাহিৰৰ আপোনালোকে একো দিব নোৱাৰে। Mr. Pareng, probably we'd like to have your views. One matter we had fixed up at 12 o'clock.
Yes,
That yesterday's that notification, have you noticed it?
yes,
Someone
I have seen, my lord, I have gone through. That issue, my lord.
There we have two concerns. Say in this case also, Lordship had brought it to our notice. In that Kulsum case, one way just now it was over. In page 74, at the end of the opinion of the tribunal, it says in exercise of the power under 313 of the Foreign Tribunal 64, OP Kulsum be taken into custody, kept as internee in appropriate place till she is pushed back. Okay. I think for these kind of observations, that letter of the Deputy Secretary had been issued. That the tribunal cannot pass these kind of orders or should not pass this kind of orders. Firstly, one issue is whether the tribunal can pass or cannot pass. This is another aspect that depends. But again, if you see section 313, clause 313, 313 itself provides where a proceedee fails to prove whether she is a foreigner or not and also able to arrange for bail, shall be detained and kept in internment or detention center. So what the tribunal is doing, tribunal is only reflecting the statutory provision. They are not doing anything beyond that. So why the particular home or the political B department of the government of Assam now wants, it's almost a direction to the tribunals that don't issue these kind of observations. This is one. Two, tribunals are exercising judicial powers. Can an executive authority ever restrict a judicial authority? Don't do this or don't do that. Possibly, fundamentally, it cannot be. Even if the reason is right, still you cannot do it. Firstly, whether the reason is right or wrong. Secondly, even if the reason is right, you cannot do it. Tomorrow, what will happen? Suppose Supreme Court lays down certain guidelines as regards bail. Okay. And in spite of this, the magistrate is granting bail. Can the Home Department ever write to the magistrate that, see, this is the formulation by the Supreme Court? Don't grant bail. Can they do it? What will be the remedy? If the magistrate is doing it, remedy is bring it to the notice of the higher forum in the hierarchy, whichever it is, that this order is beyond this jurisdiction or it is contrary to the provisions of the law. But the executive authority cannot direct a judicial authority. We are more concerned with the second aspect. So if you are having any concern with this kind of additions being made by the tribunal, you can bring it to our notice in any of this proceeding that we are holding. And if we find that, yes, the tribunal ought not to do it, we'll pass our order. We can direct the tribunals that don't add this kind of provisions in your opinions and stick only to the opinion itself.
That's true, my lord. But my information is that this has come from the judicial department.
Therefore, we require the
Yes.
judicial department
Whether-
also
I
to
don't know
remain
whether
present.
judicial department has some materials.
Therefore, we require that's why Mr. Paying said, even if you have material,
Yes, my lord.
you
This-
cannot do it.
It should be left to the High Court only.
If
but-
there are materials, it is for the Home Department or the government of Assam to bring it to the notice of the court in any of these orders, wherever it is provided.
My lord, I don't know if there is any order of this honorable court. If there is, probably,
If there is order, somebody is doing it, file a contempt.
yes. my
Still, you cannot dictate a judicial authority. Once you allow it, a dangerous precedent will be set in tomorrow.
This is not
Let
even,
the judicial authority do its work in a right manner or wrong manner. If it is wrong manner, bring it to the notice of the next higher forum, which will take care of it.
yes.
But not that the executive is directly going to interfere with the judicial authority, say that don't do it. It will be,
That is wrong. my lord.
that will be. 227. Everything.
I'll be there, my lord.
No, so you're pointing out that 227 power of the High Court is also applicable. If the tribunals are doing something they are not to do, bring it to the notice of the court. Instead of a deputy secretary writing to the directly addressing the member tribunal, don't do this.
That can be pressed to the honorable court also.
We are finding it a little unacceptable. A Kulsum case to Beleket also. We'll take it up. Kulsum, whatever order is passed, that is passed regarding that extra. And thirdly, even if there is a provision, it's not a direction.
Yes.
It has to be considered to be a part of the opinion. And opinions are not binding on the government.
Yes, that is true. We may accept it or
You
we may not accept
may
it.
not accept it. So how does it matter whether one extra paragraph is added or it is not added? But fundamentally, we are on that issue, whether an executive authority should issue any direction to the judicial authority, asking it to restrain itself in any manner. Yes,
Horendra Bepari, Horen Bepari,
page number.
31 lordship. Bari Pukuri.
This is a certificate copy.
Yes, voter talika promanito nokol.
No call from monitor. Okay. So Horendra Bepari, he is the father.
Horen Bepari,
Susila is the mother.
Shushila is the mother.
This is of 1966.
Then 70,
Page number.
page number lordship 32.
No, 1966. Horendra
36,
father.
70
Or
voters
gaon naam Bari.
Pukuri.
Bari Pukuri Protham Khanda. Now which document will show Horendra is the father?
Then DW2 and 85 voters list, page 33 lordship.
Page 33,
Not, sorry, not 33 lordship, 34,
34. This
Yes,
is
Lord.
97.
97. Horen Bepari,
Bari Pukhuri, same place.
same place.
Horen
Nogendra
Bepari,
Bepari.
father.
Nogendra Bepari. Nogendra
Bama
Bepari as
Sono.
adduced evidence. Nogendra Bepari,
Nogendra, he is the brother.
brother, adduced evidence as DW2.
So now,
Panchayat certificate she has exhibited, and even the,
who is Austir? Austir is another brother.
yes. And she also had submitted two documents. One is the Panchayat certificate, one is the next to kin certificate. Next of kin. Next of kin I have not annexed along with my,
What
Petition.
is the evidentiary value of a next of kin certificate? See, next of kin certificate is
Yes.
relevant, say, in a succession case.
even in the
Okay,
nodal-
there
Yes,
it is relevant
yes,
because the other siblings may come and object to it.
yes, lordship.
Suppose there are 3 siblings.
Hmm.
Fourth one, not being a sibling, obtains a next of kin certificate,
Yes, lordship.
produces before the succession court, saying that I am also entitled to this inheritance. There, the occasion is there for the other siblings to come and say that the fourth one is not our sibling. Either is wrongly obtained or this. 2, next of kin is available on being asked. Or maybe a little bit of preliminary material should be asked.
Materials are
Ha.
asked.
Preliminary materials. It's not a complete process by which, if it is established that it is established for once and all forever. It's not like that. So succession is a good situation. The other kins will come and object to it. But here is a case, the other kins will not come and object to it. Can you establish your descendants
Then
only from a next of kin certificate in a circumstance where the process of issuing the certificate itself is a little loose?
but my brother's name, where he has casted vote along with my father, and his name also is there in that document, will also and he has adduced evidence. It can be.
No, his
corroborated.
evidence
Yes,
we
Lord.
will take note of. We'll take note
Yes.
of Nagendra Bepari's evidence.
Yes, Lordship.
From
And the panchayat
from that
document,
point of view, we have, there is no difficulty.
and the panchayat
We are asking you
understood.
next of kin certificate standing on its own to establish that X is the son of Y.
Not only in succession cases, even in inheritance of property also that
But
is.
there, Madam Ghosh,
Yes, Lord.
the real next of kin always has an opportunity to have their say on it. When the other next of kin, they do not object, that means the fourth one is also a next of kin. Son or daughter of the same father. But when that aspect is ruled out, or that situation does not arise, only on a next of kin certificate, is it conclusively proved, or it is, has its, for the purpose of corroboration, it has its evidentiary value.
Corroboration of
I don't think it is,
corroboration.
for corroboration, definitely yes.
And her panchayat certificate was there, but panchayat was not.
Again,
proved.
panchayat,
Yes, Lord. Okay.
yes, Mr. Paing, what about the brother's evidence, Nagendra Bepari? On. The decision will be easy. For the verification process, now it is actually. এখন কিবা এখন কাগজ খুজিব আৰু কিবা এখন লৈ আহক।
26.
No, the brother has said her name appeared in the voter list of 1985 at Village Pukuri, Borpukuri Part 2. If that document is available,
Hmm,
probably
It's available.
Which document?
this.
33.
The evidence is page 25.
It is headed, yeah. Videshi Mandal, 85. 33 page of it.
Yes, Mr. Paing.
My lord, what my point is that, my lord, page 25, my lord. 25 is the evidence of my lord, the brother.
Page 25,
Yes,
that Nagendra.
Nagendra Bepari.
Was Nagendra cross-examined?
Probably this part is cross-examined.
Crossed.
This is the deposition only now.
Disposition of it.
This is
Cross-
evidence in chief of
Yes, yes.
Yes,
Horidasi Mondal. Who is Horidasi?
Horidas is the petitioner.
Acha, Horidasi is the petitioner.
Her name and.
And
Swalan.
25 DW to Nagendra.
Horidas.
Her name, my lord, in the second line of the question, it is same. Her name enlisted in the voter list of 1995 and Borpokuri Part 2,
1985.
Where you were reading, which page?
page 25.
25, huh?
The
Second
vernacular.
line.
Vernacular.
She got married in the year 1977. Her name enlisted in the voter list
After
of
marriage also must be in Baripokhuri Part 2 only.
Yes, same village.
So this 85
Yes.
is the entry after her marriage. So she will be shown as the wife of so and so,
Yes.
not as a daughter of so and so.
Yes. Page 33.
page 33 is the 85 voter list.
Hmm.
Page 33 is the 85.
33,
Three lordship.
1970. 733 is Horendra and Susila. It's,
33.
oh no, sorry,
lordship.
33,
Three.
85.
Santosh husband.
Husband.
Whose name?
Here she is claiming that the BDC Mandal is Haridasi.
Haridasi alias Videshi.
So you are rightly declared to be a foreigner. Going by your name.
Name itself is BDC Mandal.
Get protection lordship.
Sorry,
I'll get protection lordship.
protection from whom? No,
Because
it's a self-declaration of yours by adopting that name.
my in-laws have kept this name.
So your in-laws have declared you to be a foreigner. So what to do? There may be a reason, Mr. Payne. In some of the families, the names, the meaning thereof are taken in a little sensitive manner. When the name is Haridasi, it has a particular meaning of its own. Possibly that meaning is not acceptable to the family. So after marriage, the family changed the name. But unfortunately, without realizing the meaning of the new name given. Sometimes it happens. I have noticed in some of these proceedings only. In some families, the meaning of the name is quite a little sensitive, or it has similarity with the name of some other existing member of that family. So they do a this thing namakaran after the marriage, and whole family gives a different name to that person. That from today you are so and so. Anyway, we are not relying on this one.
Yes.
So why get into all these issues? You go and cross-examine Nagendra Bepari.
Yes, lordship.
Heard, no? Heard them as the host and counsel for the petitioner. The petitioner Haridasi Mandal, alias Bideshi Mandal, had been referred to the
Foreigners Tribunal number 2,
Foreigners
Bongaigaon,
Tribunal number 2, Bongaigaon at Abhayapuri,
page 14, lordship.
resulting in registration of case number BNGN/FT-2/APR/73/2016. The tribunal rendered an opinion dated 7/12/2018 declaring the petitioner to be a foreigner, being agreed this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1966 of village Baripokhuri, first part 1, which contains the name of Harendra Bepari, son of Bama. What is Bama?
Actually, is Bama Choron.
Bama Charan, son of Bama Charan.
It's read Bama.
Bama or Rama?
Rama, I think, lordship. Rama Choron.
Son of Ramacharan at serial 137, and that of Susila, wife of Harendra, at serial 138. Similarly, the voters list of 1970 of village Baripokhuri part 1 also contains the name of Harendra Bepari, son of late Ramacharan and Sushila, wife of Harendra. It is claimed that Harendra Bepari of the 1966 voters list of village Baripukhuri Part 1 is the father of the petitioner. As the father is no more, the petitioner now refers to the voters list of 2016 of village Baripukhuri Part 2. No, before that was better this. No, the petition is at present no more. The petitioner refers to the voters list of 1997 of village Baripukhuri, which contains the name of Haren Bepari, son of Bamacharan Bepari, at serial 84, and that of Nagendra Bepari, son of Harendra Bepari, at serial 86. And both are shown to be residing in the same house number 28. Accordingly, the petitioner seeks to establish that Nagendra Bepari is the son of Harendra Bepari of the 1966 voters list of village Baripukhuri Part 1. And Nagendra Bepari, through his deposition as DW2, had established that the petitioner is the daughter of Harendra Bepari. But it is noticed that DW2 Nagendra Bepari had not been adequately cross-examined by the authorities in the Home Department of the Government of Assam, so as to enable the court to make appropriate to appreciate the evidence of DW2 in the appropriate manner. In view of the above, remanded back to the tribunal to enable the Home Department to cross-examine DW2 Nagendra Bepari, son of Harendra Bepari, as regards the veracity of the evidence being led that the petitioner Haridasi Mondal, alias Bideshi Mondal, is the daughter of Harendra Bepari of the 1966 voters list of village Baripukhuri Part 1. It is clarified that the petitioner, the maiden name of the petitioner was Haridasi. But after her marriage, at the insistence of the in-laws, the name was changed to Bideshi. But be that as it may, the determination had been made by the tribunal as to whether Haridasi is a citizen as referred. One Home Department make all verification and Baki can say.
Deeply obliged.
5 and 6.
May I please, Your Lordship? But this expert order by is 50 or
Expertise order of which year?
16 my lord.
Hmm?
Expert order 16 my lord, and
Yes,
there-
Mr. Sharma. Hmm. Yes, If you go again, where is it? Mr. Mullah,
my lord.
why while moving the petition, you made this matter to be listed along with WBC 9038?
My lord, both are brothers, my lord. He is the elder
Both are
brother.
brothers.
Next one is his younger brother, my lord.
But brothers' case cannot be determined as brothers. Every case has to be determined individually whether he is a citizen or not. Both the matters are listed today. Yes, Mr. Sharma. How much cost quantified by you?
Lordship,
Brother is also ex
After,
parte.
after receipt of notice, my lord petitioner failed to appear before the.
I know how much cost.
Lordship may impose the as
How
things
much?
with lordship, 5,000 lordship.
5,000.
Otherwise, same things will repeat again lordship.
You to ex parte 5,000. It is same format. Second one, 9038, that's also ex parte. So the fine should be double because the brothers are having a habit of escaping from the tribunal. It's a family trait. So 10,000 each. So that the brothers don't conspire again, let us avoid the tribunal.
5,000 is low.
Don't do all this. You don't gain anything. But you have gained in one aspect, you have delayed the whole process by about 5 years. It's pending in the High Court for almost now 4 years. These are ex parte orders of 2016. Notice must have been issued long time back. See the advantage you have taken of the system by not appearing. And the advantage is for your own advantage. I can't prove that I am a citizen, let me delay the thing by doing all this. So why the cost should not be more? I think this cost should come up to something like 50,000, etc. A little deterrence should also be there for everyone. What we are imposing is only a nominal cost. And you will be ready to pay this 3,000 or 5,000 every time. But how you gain is you see. One whole generation will gain this way. You have already gained by about 15 years till now. Do it once more, you'll gain for another 15 years. One generation is already over.
Yes, lordship.
So why should the cost remain only at an, why should it be only it should be a nominal cost? And see the expense you are making. Now the government is required to maintain a tribunal. Tribunal could have decided this matter long time back. For you, one tribunal has to exist further for the next at least 10-15 years. I think the cost should be a little higher. Initially, we imposed the nominal cost, it's okay. But now as it appears that it's a repeated habit of these people. And to take the benefit of a few decades by doing it, just disappear from the tribunal. Let them do whatever you do. Now you must be thinking, let the High Court do whatever it does. I'll pay some money.
May I pray one thing, 5,000 in this case, and in next case, 10,000 might have, I pray that.
That is also inadequate, we believe. Let the cost be 5,000 per year from the date of the notice. Or at least from the date of your non-appearance. Yes, Mr. Ahmed, are you not taking advantage of the situation?
Right.
10,000
10,000 maybe, both are 10,000.
It is. We also put up one progressive formula. From 3,000, we came to 5,000. Now we are going to 10,000. From now onwards, every ex parte order, 2,000 will be added to that cost. Next case will be 12,000. The one after that will be 14,000 and go on and on. Otherwise, there must be some deterrence somewhere. Otherwise,
Right.
either it's advice given by somebody or somebody is thinking on its own. Then let us run away from the tribunal. Next 20, 30 years will go by doing this only. Or we start doing one more. We require you to discharge the burden right here before us. Show us the material that you are a citizen, only then we'll give you the opportunity to appear. Prima facie if you satisfy. Otherwise, it will be another waste of time. A man who had run away from the tribunal means he does not have material to prove his citizenship. That's why he ran away. Now you prove that you are a citizen first. Once you can prima facie satisfy the court that there are materials to prove you are a citizen, then we'll allow you to set aside the ex parte.
His father was also suspected to be foreigner. He
Now, who
contacted-
is this? Azizul Haq. Who is the
My
father of Azizul Haq?
My lord, Muhammad Ali.
Muhammad Ali. Which page his name
Yes,
appears?
my lord, page 35. This
Page
is-
35.
This is the order. His father was suspected and then declared Indian, my lord.
Page 35 is some court order. We are not interested.
Yes, my
We want to know who is the father.
father, my lord. His grandfather's name appeared in the voter list of 1966, my lord.
Page number.
Page, my lord, 21, my lord.
21.
Yes, next page, my lord.
Ujan Petla, Part 1, Golaganj, Dhubri, 66. Lalu Sheikh is the father.
Is the grandfather, my lord.
Grandfather. Okay. Now, who is the father?
Now, father, my lord, Muhammad Ali, my lord.
Page number.
My lord, page 28, my lord.
Muhammad Ali is the father.
My lord.
Now, which document will show that Azizul Haq is the son of Muhammad Ali?
My lord, 2005 voter list,
Page number.
or my lord,
Page number.
2005. My lord, page 40, my lord.
Page number
Page 40, 40.
40. You had some good documents. Why did you escape from the tribunal?
His wife, my lord, notice was served, my lord, to his wife. His wife, my lord, was going to parental house. And after coming back, after 7-8 days, my lord, she, my lord, perhaps did not give any importance, wife, or it went missing, my lord.
No,
she did not-
after 7-8 years, you could have gone, be fair to the tribunal. See, this had happened with me. Now here I am present with all the documents. Please examine my case.
Yes, my lord.
I don't think the tribunal would have refused you.
Yes, my lord.
Or had the tribunal refused you, could have come to the High Court. We would have corrected it.
And his father was also an employee, my lord, in the department of post department. In the department
We are
of
not on merit of a case. We are asking you why are not fair to the system and prove your citizenship if you all these documents are there. Third Minister. Mr. A.F.N. Munda, learned counsel for the petitioner also. The petitioner Azizul Haq, alias Azizul Rahman Sheikh, had been referred to the Foreigners Tribunal number number 2, Dhubri, for rendering an opinion as to whether, page 25, as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number 192/GKJ/06. The tribunal rendered an ex parte opinion dated 29/10/2010, declaring the petitioner to be a foreigner. The reasoning of the tribunal is that after having noticed the petitioner Muhammad, this is not your order, this is
My
Muhammad
lord,
Ali,
Page 51, my lord.
51. So it is dated the case number FT bracket 10 TMH/123/2015, dated 2/2/2016. Ex parte order. The tribunal took note that notice was issued to the petitioner, which was returned served in the manner as provided under Clause 3 of the Foreigner Tribunal's Order 1964, but in spite of having received notice, the petitioner remained absent on several dates without taking any step, and accordingly, a matter was fixed for ex parte consideration, and thereupon the ex parte opinion was rendered. Considering the conduct of the petitioner as reflected in the order of the tribunal, no infirmity can be noticed in the ex parte order of 2/2/2016. In the writ proceeding, the petitioner refers to the voters list of 1966 of village Ujan Petla Part 1, which contains the name of Lalu Sheikh, son of Khela Sheikh at serial 600, as well as the voters list of 1979 of village Ujan Petla Part 1, which contains the name of Muhammad Ali, son of Lalu Sheikh at serial 1066. It is claimed that Muhammad Ali is the father of the petitioner. Full stop. The petitioner also relies upon certain school certificates issued by, where is the school certificate? Which page?
Certificate, my lord. Page 38, my lord.
38. School certificate issued by the headmaster of South Jaldaba ME School, which contains the information that Azizul Haq is the son of Muhammad Ali Sheikh of village Ujan Petla Part 1. But, full stop. But as the petitioner did not appear before the tribunal, no opportunity could be availed by him to examine the headmaster of the school. Considering the material surveillance record which the petitioner relies upon to discharge the burden under Section 9 of the Foreigners Tribunal Order under Section Foreigners Act 1946, for the interest of justice, we remand the matter back to the tribunal to give an opportunity to the petitioner to appear before the tribunal and discharge the burden as indicated above. But however, for the conduct of the petitioner and also taking note that he had taken advantage of the situation, since the year 2015 by not appearing before the tribunal, comma, the petitioner to pay a cost of rupees 10,000 to be paid to the District Legal Services Authority, Dibrugarh, Dhubri, and after showing proof of the payment of cost to appear before the tribunal on so and so.
This 53, I filed a vacation petition that was also rejected.
It stated the petitioner filed a petition for vacating the expertise which was rejected.
Next one. This is also younger brother one. Same manner.
Same.
Only case number is different, otherwise
Those voters list also same.
voter list same. but
The
this
son of Muhammad Ali.
Muhammad Ali.
Any
Only
school certificate?
school certificate is different. This school name is different.
Give the page number to our school certificate also.
Well, page 38.
Same ME school,
No, madam.
different ME school. Into side of school certificate. You give the information to the.
Madam.
Same order.
And here also we filed vacation petition that is rejected same date manner. Deeply obliged.
Item 7,
Next ex parte order cost will be 12,000.
So this is a contested case. Case 20.
Not ex parte. Sobita Roy, yes, who is the father?
Case 21, Lord.
Says 21.
My father name is was there, Lordship, in 66.
66, Hamunanga Part 2, Agawadi, Dhupri. Doitaram Bormon,
Yes, Lord.
he is the father.
Next, Lordship. Case 23. Case 23, 1970 voter.
It's okay. Now, which document will show? Doitaram Bormon is there.
Case 29, Lord.
29.
This is the school certificate.
Khatar High School, Sobita Roy.
Headmaster was examined, Lordship, that is page 39.
Did the school register contain the name Sobita Roy or it contained? Acha, Doitanath Roy. But this is Doitanath Roy. The voters list is Doitanath Bormon.
Yes,
The same person or different person?
same person.
How will you prove it?
You have mentioned that these are same persons. Lordship.
Mention is not proving.
Yes. Same village, Lordship, no shifting in this case, Lordship.
We understand.
beginning.
Mention is not proving because word mention and one word proving, they are not synonymous. নামটো দেখিলে বেছি আহিছে
Lordship, we have also annexed the Panchayat certificate, but author was not examined, Lordship. That is page 42, wherein father name was mentioned, Doitaram Bormon, Lordship.
What was held by the Supreme Court, Panchayat certificate, it was for the purpose of NRC. NRC, the difference is NRC authority already had a wide compilation of data with them. So one document was good enough to cross-check everything. But tribunals don't have any data. So for the purpose of cross-checking, the certificate of the panchayat is relevant. And that too only for married ladies, not for everybody else. But making panchayat certificate to be the core document to show, I don't think even the Supreme Court has approved and accepted to that extent. The petitioner relies upon the voters list of 1966 of village Bhamundonga Part 2, which contains the name of Daitoram Bormon, son of Katiram. And it is claimed that Daitoram Bormon is the father of the petitioner. To substantiate the same, school certificate from Ghotar High School, Kanuri is relied upon, which contains the information that Sobita Roy is the daughter of Daitonath Roy of village Bhamundonga Part 2. Whether Daitonath Bormon of the 1966 voters list and Daitonath Roy of the school certificate are one and the same person, the superintendent of police boarded to make a verification and submit a report before the court.
Item 8.
May I please, your lordship?
Yes, Abdul Ali.
Father is Kurpan Ali, lordship. Page 50, lordship.
Now, as a result, what is happening, you know, we are giving final hearing.
Notice was
The new matters are being heard, giving preference over the old matters. And there is no reason also why it should be listed as motion, because notice was already issued.
Yes, lordship. On 23/5. 2022.
Don't you think so? The matters which is 1 year old is getting more preference for final hearing. And the matters of 6-7 years old are still pending before us. Okay, we'll hear you at the end of the list.
Yes, lordship.
Right. If you can make time, we can hear you today itself, or
Yes,
else we'll fix up that. But let us hear those 6-7-year-old
Yes, yes,
matters first.
Item 9.
Same thing.
No, lordship, here the person is in the detention, lordship. Other day, the matter came up and I had filed at least 2 affidavits, lordship.
Abdul Kalam.
Yes, lordship, which is
PW
not there in the record,
Petitioner
lordship.
seeks for
I
adjournment
filed
to
it-
provide, which indicate Johar of 65 of village Bhandara had shifted to shifting. You approved the shifting.
Yes, lordship. I had
If
filed-
they are in detention, we'll hear you with some
Yes,
preference,
yes, lordship.
but let us hear it finally.
I had filed 2 evidences of the persons who are of that Bhandara village, lordship. And the certificate was
Page number.
this, I think it's not there in the record. Let it be taken up at 2. Meanwhile, those records we will call for lordship. Because 2 affidavit, we had filed it yesterday.
Listed on, I think, Wednesday. Monday? Monday? We'll list on Monday along with the 2. affidavits.
Otherwise Friday, Lordship.
Friday. let's
Otherwise
see.
tomorrow, Lordship, the person is in detention.
Hmm.
Extra copies are not- Hmm? Before the last meeting, yeah.
Monday. Monday. Mhm.
It will be difficult, Lordship, on Friday.
Friday may or may not.
Otherwise tomorrow, Lordship.
Tomorrow. Tomorrow there is another bench. Tomorrow there will be one or two additional benches also. That will be Monday.
Yes, Lordship.
Or you want to take chance today?
Today, 2 o'clock, Lordship, I'll call for the
Running page number to call the.
running page number already we had, while filing only now, these days we are putting the running page.
You're
number.
putting it yourself.
Yes, yes, Lordship.
Let's try your luck. If it is possible, it's good.
Yes,
Otherwise,
yes,
Monday.
Lordship, yes, Lordship. No, before.
Come back.
Item 10,
We had to hear one matter in the chamber. Sometime. Yes, I can.
I don't know. This matter is pending before the learned tribunal. Lordship. Thing is that, Lordship, the petitioner wanted to produce consent certificate. That was not considered. He filed a petition, Lordship. That is, Lordship, when we filed a case 51, Lordship, and order case 54.
You want to produce a panchayat certificate. And that was, I think your mic is not
Yes,
working.
Panchayat
Panchayat
certificate,
certificate, and that was rejected.
that was rejected, Lordship.
What will happen if you produce the panchayat certificate?
For linkage, Lordship, it is necessary,
You want to link up with whom?
with father, Lordship.
No, you have to establish that X is your father. There's nothing called linkage. Link is NRC. The term linkage is derived from NRC. And the reason is NRC authorities, they're having a wide collection of material with them. Through a document, you have to link yourself with any of those material they are having. Therefore, it is called linked document. But foreigners tribunal have no material with them. It is for you to produce every material you can to establish that you are a citizen. So there is nothing called linkage. Now, suppose we allow you to produce this document, what will happen?
Link with father will be established, Lordship.
How panchayat certificate will establish the link?
Secretary will come, Lordship, will be examined before the.
Who is the secretary?
Panchayat secretary, Lordship. We
I
have,
know panchayat secretary. Who is he? How does he know? If the panchayat secretary will give evidence on the basis of any public, any material on public domain. Suppose he is maintaining a public record, that from that record, he wants to give evidence, like the school headmaster, they give the evidence. Because headmaster is retaining the school admission register, which is a public record. From that public record, he gives the evidence. So Panchayat secretary does not maintain any record.
Then Lordship,
So
any
from
other-
where will he give a certificate? Understood?
Lordship. In that case.
We need a person who has personal knowledge about the existence of that fact that X is your father. He may be a Panchayat secretary, he may not be a Panchayat secretary, he may be an ordinary citizen, a neighbor also. So you go and examine the person, and if this Panchayat secretary actually has a personal knowledge, you don't need a certificate. You just call him as a witness.
Any other witness, Lordship, in that case. Lordship?
Any other witness, anybody you want, anybody you feel who may have the knowledge whether X is the father of Y or not. Bring that person.
Lordship.
But he'll also have to show before the tribunal what is the source of his knowledge, whatever he said, that's all. Heard Mr. M.I. Hussain, learn come. We clarify to that extent and allow it. Learn counsel for the petition also. The petitioner Mumtaz Begum had been referred to the Foreigners Tribunal number
Bongaigaon 1, Lordship.
number 1 Bongaigaon for rendering an opinion as to whether she is a person who entered the state of Assam from the specified territory on or after 25/3/1971. In course of the proceeding, the where is the order impute? Page number
Page 54, Lordship.
54, Lordship.
54.
54. Order dated 21/3/23.
In course of the proceeding, the petitioner presented a certificate from the Gaon Panchayat Secretary dated 18/1/2023 and made a prayer that the said certificate be accepted by claiming that it is a new discovery. The tribunal, on being not satisfied that it is a new discovery, had rejected the prayer. By arriving at a conclusion that the certificate of a Gaon Panchayat secretary cannot be treated as a new discovery. We see no reason as to why. We see no reason to not accept the said view of the tribunal. But at the same time, when the petitioner is required to discharge his burden under, discharge her burden under Section 9 of the Foreigners Act 1946, that he is a citizen, he must be given all opportunities as may be available to produce any relevant material which may indicate that he is a citizen. Usually, the method adopted is that a person is identified from a given voters list, which may indicate that the said person is a citizen, and thereafter prove that the person concerned is the father of the proceeding. In the instant case, the petitioner relied on who is the father?
Other page 18, Lordship.
Page
14,
18.
14, Lordship.
Page
Abu
14.
Bakr.
Page 14.
Yes, Lordship.
Relied on the voters list of 1966 of village Numberpara Part 3
Number one.
under Sri Jangram Circle in the present Bongaigaon district, which contains the name of Abu Bakr, son of A. Shakur, at serial number 3. A claim is made that Abu Bakr, son of Shakur, of serial 3 of the voters list of 1966 of village Numberpara Part 3, is the father of the petitioner. The petitioner accordingly intended to rely upon a Gaon Panchayat certificate of the Gaon Panchayat secretary, which may contain the information that the petitioner is the son of Abu Bakr of the 1966 voters list of village Numbepara Part 3. As already held, a certificate depicts the existence of a fact which is vouched upon by the author of the by the person issuing the certificate. In other words, the existing fact that may be reflected in a certificate would have to be within the knowledge of the person who issues the certificate, meaning thereby either the person concerned is the custodian of a public record from which the information is derived, or the person concerned may have personal knowledge about the existence of the fact. If the petitioner intends to prove through the certificate of the Gaon Panchayat secretary that Abu Bakr of the 1966 voters list of village Numbepara Part 3 is the father of the petitioner, the core requirement would be to examine the person who had issued the certificate to depose before the tribunal, firstly as to his source of knowledge, and secondly that as per such knowledge, Abu Bakr of the 1966 voters list of village Numbepara is the father of the petitioner. Irrespective of the certificate, the said deposition can be made by any person, including that of a Gaon Panchayat secretary, provided the Gaon Panchayat secretary has appropriate knowledge about the existence of the fact that Abu Bakr of the 1966 voters list of village Numbepara Part 3 is the father of the petitioner. And such knowledge may flow either from any public record that may be maintained by that person, including the Gaon Panchayat secretary. Circumstance under which the personal knowledge had been acquired would also have to be explained. It's okay, Madam Verma? I think it's complete by all this. From such point of view, for the ends of justice and in order to enable the petitioner to discharge the burden under Section 9 of the Foreigners Act 1946, the petitioner may produce any such person who may have the knowledge, as indicated above, that Abu Bakr of the 1966 voters list of village Numbepara Part 2 is the father of the petitioner. And if any such person is presented, the said person may be allowed to depose before the tribunal, and once the deposition is made, the respondents in the Home Department may cross-examine such person in order to extract the veracity of the such deposition.
A school certificate is also there. They can examine the headmaster.
If the petitioner is relying upon a school certificate, similarly, as laid down by this court in its judgment, dated so and so in so and so.
Rupadas.
In Rupadas way in India, the petitioner may also examine the headmaster of the school along with the original school records from which such information could have been obtained. We are allowing something more.
Highly obliged.
Lordship has fixed a date for the remand.
Petitioner to appear before the tribunal on so and so.
For July.
And
For July.
upon undertaking the process, a written order may be passed by the tribunal.
Item 31.
May I please, Your Lordship? My lord, in this case, on this previous day, Qazi was forfeited.
Where is the marriage register of what language he understands? Just ask him.
They can understand Assamese also. Lordship.
Huh?
They can understand Assamese also.
He can understand. Boikhon anise? Sound?
31.
You are not supposed to handle. You are a counsel for the petitioner. You can examine if you want, but not handle. Where is the deposition of DW5 page number?
Page number 55.
55.
Yes, sir. Cross is page 56.
Original format. এখানে original যদি হয়। Demand number of 2017. Even if it is 74 or even the 74 document no হয়। No হয় এখানে। No। When did the marriage take place?
As per the matter, 5/1/1994,
94.
Yes, sir.
When was the marriage registered?
21/10/2017, madam. 21/11/2017.
Under which provision of law a marriage solemnized in 94 can be registered in 2017? That's why possibly we require the
My lord,
original.
yes, your lordship has
See, under the Special Marriage Act, suppose a couple had married much earlier, but their marriage was not registered. That marriage can be registered. Suppose, I think for going to some countries like Europe, etc., you need those marriage certificates for travel purpose. Mainly they do it for that reason. But that's a specific provision of law. Under Special Marriage Act, you can do it. But under the Muslim law of marriage, is there any such provision? The marriage will be solemnized in 94 and it will be registered by the Qazi in 2017. Is there any such provision? Where is Mr. Sigdar? Mr. Sigdar, is there any such provision in the Muslim law of marriage? Because what we understand, the Muslim marriage is solemnized by the Qazi or any person equivalent to a Qazi, and by following certain rituals and procedures.
My-
And at the time when the marriage is solemnized, it is also registered in the Kabinnama.
Yes. It should be done at the time of marriage
Huh.
normally.
Is
But,
there any provision that the marriage will take place in 94 and it will be registered by the Kazi in
in the Qazi Act,
2017?
there is no such provision.
So that means it is the second marriage of that person.
Or it does-
It's a marriage of a person who is already married. Special Marriage Act is different. You are registering a marriage which took place much earlier. And there is a specific provision for that.
For marriage, my lord, for.
Because why we are saying so, when you register an earlier solemnized marriage under the Special Marriage Act, what you are required to do is to bring all the materials to prove before the registering authority that the marriage had earlier took place.
Yes,
So marriage that took place in the past is now being registered. It's not a new marriage. That old marriage is now being registered and put in a more formal manner. But
but the Qazi,
just,
special marriage can be done, but the Qazi, there is no such. provision.
just see this document. You will please examine for yourself. So
But
we
this
had
is-
some doubts. That's why we required the presence of the Qazi.
But if it is, my lord, earlier socially marriage was done, subsequently
No.
it is registered before the Qazi.
No, there is no provision of social marriage
But,
in
Under
Muslim
law,
marriage.
there is bar also,
But there is no provision also.
provision also. If marriage is performed socially
No,
earlier.
no, there is no provision. Under the Hindu law, it is yes. If somebody brings in the evidence that those few steps have been performed by somebody, marriage is done. But that is not available in Muslim law. At least,
Like
even if
the,
there's
my lord,
provision, I have not
Birth
come
and
across.
Registration Act, there is a bar, there is a procedure. My lord, there should be a declaration by the, before the
No,
magistrate.
Mullah Khan song.
But in the marriage, for the purpose of marriage, I think there is many bar also.
But
If
there
marriage
is
is performed earlier socially,
Mr. When the law does not provide for it, there is no question of bar. You have to perform certain act, which according to the law will give a recognition that marriage had taken place. Two people just can't say, yes, from today we are married. So we are married because there is no bar. And after 20 years, we'll think of registering our marriage. That is not there. Even if you have the expression you are using that there is no bar, that no bar will also require certain acts to be performed. Only when those acts are performed, the marriage happens. If those acts are not performed, there is no marriage. Somebody may feel that we are married, but law will not say that you are married. Check up the law.
my lord, I think, my lord, if the
You-
persons who were present at the time of the Muslim marriage, my lord, if a proposal and acceptance is made in presence of two witnesses, then that is a valid marriage.
Where is the provision?
If.
No,
yes,
where
my
is the provision?
Yes, my lord. Mohammedan law, that is, that may be there.
we-
Proposal and acceptance.
We are getting the Mullah Muhammadan law. Please check out where it is.
My lord, today I am not with the book, my lord.
No, we are providing with the book. Don't worry.
Section 252 in the Muhammad principles of
এখন
Mohammedan law.
দিয়েছেন। কার মোল্লা নাকি?
Yes, my lord. It's Mullah book. No, my lord, it is, oh, yes, Mullah.
কিন্তু এখানে স্বাভাবিক certificate no difficulty. But it must be on the base of an entry that
Capacity of marriage. Lunatics. Essentials of marriage. My lord, section 252. There is clear provision. যারা পারফর্ম করছে তারাই যদি
These are essentials of a marriage.
Yes, my lord.
Essentials of a marriage is something different. There should be a proposal made by one or on behalf of one party and the acceptance of the proposal by the other in the presence and hearing of two male or one male and two female witnesses who must be the same. So
If the same witnesses.
understand.
come
So,
my
so
lord, and
now somebody must prove it that this act had taken place in 1994. Who had proved it?
my lord, same persons who were.
No, who
present
had
in the
proved it?
marriage,
Now,
They should, my lord,
Mr.
come.
Sikdar, we understand what you are saying. Suppose in 1994, this section 252 act had already taken place. Either you register it at then and there by the Qazi or you don't register it. Okay. Now suppose you don't register it. Under section 252, your marriage had already taken place.
My lord.
Now, where is the provision of a Qazi to register it subsequently? Because a Qazi under the law that is applicable only registers the marriage. He does not register the marriage post facto at a much later date. The marriage takes place either by the registration or by 252, either of the two.
My lord, so far the Qazi Act, my lord, there is no specific,
Again, you are on bar.
either allowing or.
Where is that? Where is
The Qazi Act is to be
no,
seen.
no,
my lord.
there
I
are
think there is no bar.
There is, but how can you register? And even if you register, there must be some material before you
Yes,
that this 252 act had taken place on so and so date. That is absent. Look at the register. We have read it. Reading of the register shows that it had taken place when these entries were made.
my lord, that can be proved by examining the witnesses, my lord. If
Who,
veracity can be proved.
we are not on the validity of somebody's marriage. We are only on the,
Delayed registration. my lord.
no, we are not on that also. We are not deciding the marriage of that party. What we are deciding is this document is relied upon to show that X is the father of Y. Only to that purpose. Now, this is a document of 2017, after the notice was issued by the tribunal. Had it been a material of 1994 when the marriage took place, we would have accepted it. Like we accept the school admission register. Now this is equivalent to preparing the school admission register after the notice of the tribunal. We are not questioning the validity of a marriage. This is.
Documents, these documentation, whether these documents.
So what I tried to, why we call for the Qazi as well as the original register, we wanted to check up whether this certificate is issued on the basis of some entries made in 1994.
Yes. Well, whether.
But a feeling of the touch of the paper itself shows that it's a document of 2017, not of 1994.
No reference of previous.
Not
versions.
reference, feeling.
My lord. My lord.
What 30-year-old document will look and feel different. The paper becomes more brittle, color changes, everything happens.
Well, we have to see the Qazi Act, whether the Qazi has any power. I think there
Even
is no
if they can
specific
do-
provision.
Even if the Qazi has the power, that will be based upon some
Previous records.
previous record.
Well, the earlier marriage, if it is done on proposal and acceptance in
Now,
presence of
what
witnesses.
happened, Mr. Sikdar, you see, as we see it, somebody must have given the legal advice that nowadays the Kabinnama is an acceptable document to prove that X is the daughter of Y. They asked this person, do we have Kabinnama? They said, no, we got married in a different way. We got married in the presence of one male and two female, or in the presence of two males. It's a marriage of 252 of the Mullah book. We are married that way. So better feeling comes to the mind. Prepare a Kabinnama, get the marriage registered now. This is the outcome. School admission register, why do we depend on it? Because it's an entry made long back. When the person concerned went to the ME school or LP school or wherever the person went. Now, if this admission register, and somebody will now come and say that my school did not maintain an admission register, everything was oral. So therefore, when I received a notice from the tribunal, I requested the headmaster to create an admission register, and now here is my name. Will it be acceptable? Is it?
My lord, under that situation, what
Will come back at 2 o'clock?
Well-
Take up with the Qazi also.
My lord.
Why this is being done, or is it a prevalent procedure? You ask me.
I'll see, my lord.
Otherwise, the credibility of these materials are again going down.
My lord. My lord, the witnesses of the marriage, they can be examined, my lord. Witnesses of the marriage,
Then again, it will be oral evidence.
my lord, oral evidence.
You may prove your marriage. We are not questioning that you are not married.
My lord.
We are not determined whether this couple is married, got married in 74 or not. That is not the issue before us. The issue before us is whether this person is the daughter of so and so or not. Think about it.
Right.
What is the outcome?
My lord, the Qazi is before our lordship. My lord, if the Qazi is ignored, there are some vital documents, lord.
Other documents.
Other documents. Lord.
So we discharge the Qazi then.
Yes, lordship. Elderly persons of paternal village, 2 persons.
No, we wanted the original the Qazi because we found it little unusual.
Yes, lordship.
Marriage took place in 94 and the certificates are of 2017.
That is not permissible.
Huh?
That is not permissible under law.
Huh. So we wanted to check up whether the certificate is of 17 and the registration is of 94, or registration is also 17. Now it appears registration is of 17.
Yes, Lord, Section 9 of the Muslim Marriage and Divorce Act 1935. That has said that.
Come on,
it
little
should be within- That should be within a month.
registration.
Yes, registration. May I read that, my lord? On application being made to a Muslim register for registration under this Section 9. Under this act of a marriage or divorce within a month of marriage or divorce being effected, not otherwise. And
Not otherwise is also there.
Yes,
Not
my lord.
otherwise.
Specific, my lord.
Hmm.
So, my lord, he is elderly person, he may be excused and with a warning
no,
that he
we are-
should not do.
We don't want to do anything with the Qazi. We just want to his help to
My lord,
arrive at a correct conclusion. That's all.
my lord. It is
He is a private Qazi or a government Qazi? Government
My
Qazi.
lord, it is government Qazi.
No, he is a government Qazi or private Qazi.
Government Qazi? Sarkari Qazi?
Oh, Sarkari Qazi, no, apuni? Apuni ene is
This আপনাকে
আপুনি এনে যেতিয়া তেতিয়া মানুহ আহিলে আপনি আপনি he doesn't hear. Please tell him.
আপনাক কৈছে যে আপনি মানুহ এজন কোনোবা বিয়াৰ পাৰ্টি যেতে আহিলে আপনি ৰেজিষ্টাৰ নকৰিব, 1 মাহৰ ভিতৰত বিয়াটো হৈছে না নাই এইটো চাব।
কারণ আইনটো বেলেগ। আজি বাৰু আমাৰ একো দিগদাৰি নাই আপোনাৰ লগত, কিন্তু পিছত কেতিয়াবা ভৱিষ্যতে আপুনি বিপদত পৰিব পাৰে নহয়।
I will make him honest.
Tell him, explain the law also that unless this is satisfied, don't do it, because in another case somebody may, suppose what will happen if the parents of a girl files a fraud case against him,
My lord.
what will happen then? Today there is no problem with this court. For our purpose it is okay. But what will happen if he indulges in this thing and the father of a girl files a fraud case against him? What will happen then? What are you doing? You'll be in bigger trouble than in those cases. We have the government registered Qazi of Nair Alga Part 3, namely Azizur Rahman, is present before the court as required by the earlier order of 4/5/2023. The Qazi, government Qazi, has also produced the marriage register in original, perused the original marriage register. Upon examining the marriage register, it is revealed that although the marriage between the parties may have taken place in the year 1994, but the entry in the marriage register is of the year 2017. Full stop. That and more relevant would be that the entry in the marriage register is subsequent to the notice being received by the proceeding from the tribunal. We also required Mr. A.R. Sigdal, Learned Counsel, to assist the court on the provisions and procedure as regards Muslim marriage, more particularly as regards the registration of a Muslim marriage. A stand had been taken that although the marriage was actually solemnized in the year 1994, by following the requirement of section 252 of Muhammadan law by Dinshaw Mullah, that is a proposal and acceptance between the parties to the marriage in the presence of either 2 male witnesses or 1 male witness and 2 female witnesses, but the actual registration was effected in the year 2017 as entered in the marriage register. It had also been pointed out by Mr. A.R. Sigdal and Counsel that under Section 9 of the Assam Muslim Marriage and Divorce Registration Act 1935, a marriage which had already been solemnized can be registered on an application being made within 1 month of the marriage or divorce being effected and not otherwise, meaning thereby that a marriage which was solemnized in the 1994 could not have been registered in the year 2017. Further, although we are not concerned with the validity of the registration of the marriage as such, but the resultant marriage certificate is being relied upon in this proceeding to as a material to show that the petitioner Kariman Bibi
Yes, Lordship.
is the daughter of Karamat Ali of which?
Nair Alga.
Of
Nair Alga
village Nair Alga Part 3. If the marriage entries in the marriage register would have been contemporaneous to the actual event when the marriage had taken place in the 1994, perhaps the information contained in such register would have been more relevant for our purpose. But now, as the marriage had been registered only in the year 2017, and that too after receipt of the notice from the tribunal, it would be unsafe to accept the information contained in the marriage register of the year 2017 as regards as to who may be the father of the petitioner Prosidi Kariman Bibi. Mr. M.I. Hussain, Land County petitioner, states that there are some other materials of the petitioner which can also be relied upon for further hearing. List on so we'll hear you on the other day, but not this certificate. The presence of the government Qazi is dispensed with, and his assistance to the court is appreciated. আপোনাক কিবা কিবি কব সিকদার সাহেবে শুনি লব ভালকে Item 11, who is appearing? The Ghosh, where is Madam Ghosh gone?
Lordship,
Time being.
better maybe password for time.
Yes. The first time it is coming. Who is the father of Abdul Hamid?
Shahar Uddin Sheikh.
Page number.
In the voter list of
In which page?
1977 year lordship. Page number 67 year lordship.
67.
68 year lordship.
68. Dumar Toha, Goripur, 77. Who is the father?
Father is Sophia Rahman year lordship.
Sophia Rahman. How do you know that Sophia Rahman is a citizen?
Sophia Rahman year lordship. He is the citizen year lordship. I have exhibited one land document year lordship.
No,
And the
Sophia Rahman, why his name does not appear in 1970 voters list, 71 voters list?
perhaps your lordship at that time she was not attained there.
He was 25,
Yeah.
possible. Huh? Where is the name of Saharuddin, father of Sophia, in any voters list?
1966 year.
Page number
Page number 63 year.
60.
64.
Saharuddin, okay. Now, which document will show that Sophia is the father?
Lordship,
Any voters list
voter list is there.
together between Sophia and the petitioner?
School certificate your lordship I have.
Page number.
Page number 73 your lordship. Also,
73.
$75 your lordship. It's translated form. And the headmaster was examined.
Why did you annex page 74?
74 is the voter list your lordship.
I know it is a voters list. Why did you annex it?
This is the voter list of 2013 year.
We have read that.
In page
We,
73.
our ask question is, why did you annex it?
Because in this voter list, the father's name of the petitioner is there, your lordship.
Father, who is the father?
In here, your lordship, his name appeared as Sofial Hawk, your lordship.
No, no, that is okay. Who is the father?
Father is the Sofiur Rahman.
Uh,
Sofiur Rahman, but in the voter list of 2013, his name appeared as Sofial Hawk.
and who is the father of Sofiul Haq?
Is the Shaharuddin Sheikh, your lordship.
But here it is Maharuddin.
In the voter list of 1917. your
Mr.
lordship, his-
Khan, there is a difference in the name of
Yes,
Sofiul Haq. There is a difference in the name of Saharuddin and Maharuddin. There is also a difference in the name of the village. One is Dorchoka Part 1 and the other is Dumardoha Part 1.
yes.
They are not the same village.
Regarding
Therefore, we are asking you, why did you annex that voter list?
this voter list, your lordship, the name of the parents of the petitioner appeared, your lordship. They were, that is in the year of 1983, your lordship, they shifted from Dumardoha to the next village, your lordship. Dumardoha to Darsoka Part 1, your lordship.
The petitioner may provide any relevant material which may indicate that the family of Sofiur Rahman, son of Saharuddin, of the voters list of 1977 of village Dumardoha Part 1 had later on shifted to village Darsoka Part 1, resulting in the name of Sofiul Haq, son of Maharuddin, being available at serial 733, where a claim is made that Sofiul Haq of the 2013 voters list and Sofiur Rahman of the 1970 voter list are one and the same person, and also that Maharuddin of the 13 voters list and Saharuddin of the 77 voters list are the same person. List after, how much time you want?
Lordship, in this case, your lordship, regarding discrepancies of name, your lordship, the petitioner in the written statement he has
Next
submitted.
item to you.
Item 13,
Then 2 weeks, your lordship. After 2 weeks.
2 weeks.
Lordship,
No, more than the name of discrepancy in the name, we are on the village. Give that
But
information.
this man, your
Yes,
lordship,
let us hear the next council.
this man has been declared foreigner, your lordship, on the ground. The school certificate was issued after 30 years. And the next one is the voter
We'll hear you.
were not.
We'll hear you. First, you discharge your burden that you are a citizen. Rest will hear you. Yes, Madam Ghosh.
May I please your lordship? Father is Akbar Ali. Okay.
Iron Nessa, who is the father?
Ajiron Nessa, Akbar Ali, lordship.
Page number
Page number is 64, lordship.
64.
Village all along same Ujira Chor.
Ujire Shah.
Yes, lordship.
Ujire Shah is also a common village.
Yes, it's in Gwalpara, lordship.
In a lot of cases, they come from Ujire Shah.
Yes.
Ujire Shah and the name of the petitioner.
Petitioner is,
Name of the father is?
father is Akbar Ali.
Where is Akbar Ali?
Akbar Ali, page 64, lordship.
64 we are trying to read.
Yes, serial number 834,
Akbar.
Akbar Ali.
Son of,
Initial is there.
let it, Now, which document will show Akbar is the father?
And in the same 66 voters list, full list also is there, which is at page 66, wherein grandfather, grandmother, all are
Let it remain. Which document show that?
Page 97, lordship,
Akbar is the father, page 97.
97, lordship. And the contents of this was proved. Page secretary's evidence is DW3, lordship.
Page number.
Page number 58, Lordship. Sorry, page 60, Lordship. 60 is DW3. Swetanat Talukdar.
58,
58 is,
58, Setana Talukdar.
yes.
The DW3 Setana Talukdar to file an affidavit before the court stating the source of his knowledge as regards the deposition made on 12/10/2022, which is available as Annexure 5, page 58 to the writ petition.
Uncle also has reduced evidence as DW2.
Page number.
Page number 52.
Abu Talib.
Yes. His maternal maternal uncle.
That voters list, which page it was? Page number?
Page number
Page
is
64.
64
is of Uzire
Uzire
Shor,
Chor.
and
He-
Abu Talib is of
Rakosini,
Rakosini,
Garopara,
Garopara.
where she is the maternal village.
How do you know all these things? Hmm. Do you have any school certificate?
No lordship. She is illiterate.
Never went to school.
No school certificate lordship.
Kabinama?
No lordship. Was not produced before the Larnet tribal.
No, it may not be. Do you have it with you?
That I am not sure lordship.
Inquire about it. We can have the Kazi. With the marriage register. If it is there, we'll accept it.
Yes, lordship.
You may allow your petition also. Then and there.
Yes, lordship. I will.
Mhm.
Yes, lordship. I will.
But otherwise, see that DW3 Talukdar, he is a Gaon Panchayat secretary.
Yes.
And there is no public record in the Gaon Panchayat.
Application was there. He had stated that. it is-
Application.
And along with. all
Suppose you are the
documents.
secretary, I make an application, we give you a certificate. Does it mean you have personal knowledge?
Contents of the application should, what are the contents here?
And that's what we are telling you. Suppose I make a complete application to you, you are the secretary.
Yes, lordship.
Give me a certificate containing this information.
Yes.
You act
lordship.
on my application, give me a certificate. Where is your knowledge?
I got it.
Hmm.
1 week's time, lordship. I'll
This
just,
is my knowledge.
yes, lordship.
My application is my knowledge, but where is your knowledge to give that certificate?
I'll take 1 week's time, lordship, and then I'll reduce it. Her brother is there along with that, then it will be.
Oh, so
more
we
than-
require an affidavit from the secretary. Let him say from where he is saying all
That-
this thing.
How come she can bring in this person? It's a,
No,
He's
no
a
need.
a
A
government-
copy of this order be provided to the learned council for the PNRD.
and
So
she
fine,
will,
give it to the PNRD.
Yes.
and she also will adduce more evidence if whatever she can bring. Deeply.
File affidavit, bring in more
Yes,
evidence.
lordship. will bring.
Gaon Panchayat certificate. It's PNRD over there.
Item 15.
Who is the father of Lalchand?
Kindly see page 41, madam. 1966 voter list.
Josimuddin,
Madam,
he is the father.
madam.
And which document will show Josimuddin is the father?
Madam, kindly see Zoma Mundi, page 74 to 77.
Page 74. Now, connect.
Madam,
Notice interim order. Interim order to লিখার আগতে লিখিব. The petitioner relies upon the voters list of 1966 of village Gorola Farm containing the name of Josimuddin son of Bajam at serial 12. And it is claimed that Josimuddin of the 66 voter list is the father of the petitioner. To establish the same, reliance is placed on a Jamabandi in respect of a plot of land of village Gorola Palm, which contains the information that land had been mutated, comma, amongst others, in the name of Lal Mia, son of Josimuddin, in place of Josimuddin, which may be a prima facie indication that Lal Mia is the son of Josimuddin. It is claimed that Lal Mia of the Jamabandi is Lalchan Ali, alias Lalchan Muhammad Lalchan Ali, the petitioner proceeding. Prima facie case made up interim. But Mia and Ali, you have to explain later on. The petitioner would have to explain at the time of hearing
madam,
as to whether Muhammad Lalchan Ali and the petitioner and Lal Mia of the Jamavadi are one and the same person.
and one affidavit
Next.
annexure 29, page 91 to 93, madam, regarding this matter. My affidavit. Develop.
Item 16 for admission.
Develop.
16. Chaudhary. You appear 16.
Yes, Lordship, initially this writ petition was dismissed, there was review was filed. Review was allowed by this honorable court.
Now, Ajuta Khatun, who is
Ujufa
Ujufa
Khatun.
Khatun?
Her
Father,
father is Azhar Ali,
page
Lordship,
number.
page 16, Lordship.
Page 16. Azahar Ali, son of Jabbar,
Yes, Lordship.
66.
Yes, 66,
Gao-
70,
What is it? Bangalpara.
Bangalpara.
Bangalpara 66. Somewhere in Guwahati, in the Thana
Hajo
Hajo,
side, Hajo side.
Azahar Ali. Now, which documents show Azahar is the father?
Lordship, I had filed one additional affidavit wherein I brought the Jamabandi, where I have inherited the property,
Which is?
Lordship, page 95 to 99,
95.
additional affidavit. But this is of number 2 Velkor. This is of number 2 Velkor village.
Earlier was village Bangalpara, now it is village
Velkor.
Helkor.
All along voters list also I have annexed. They are there in Bangalpara. Even voters, subsequent voters list of her mother, brother, all voters list I have annexed along with this additional affidavit to wherein I brought that her mother all along casted vote till 2021. Since 66 till 2021. All the voters list I have annexed along with the additional affidavit, and her brother's name are also there. My humble prayer will be if this matter is remanded back to
The remand is not on asking, remand is on
the documents.
showing something prima facie which requires an examination.
So my brother can, Hussein Ali or Noor Islam can adduce evidence.
Where is the name of Hussein Noor along with Tasikon Nesa?
Tasirun Nisa, it's page Lordship 94.
94.
Yes, Lordship. Hussein Ali is there, Noor Islam is there. Serial, same Bangalpara,
Noor Islam.
same Bangalpara.
Yes, Mr. Sharma. Let Noor Islam come. No? Heard he voiced the concept for the petition. Azufa Khatun had been referred to the Foreigners Tribunal number
Number 4, Kamrup
number 4,
Kamrup.
Kamrup Metro,
Rural.
Kamrup
Kamrup.
Rural for
So-
rendering an opinion. Nowadays, Kamrup Rural people
It's only Kamrup.
don't like if you call them rural.
Yes, it's
They
only
like to be
Kamrup.
called Kamrup.
Kamrup, yes, Lordship.
Other one may be Kamrup Metro,
Metro.
but they are Kamrup.
Kamrup.
No, they don't. Yeah, I was only looking for a year, so Mm.
Registration of case number.
Yes, number.
Page 61, Lordship. Is the impugn order. It's HFT case number 325/2015.
An opinion dated
Opinion dated, Lordship, 15/7/2016.
had been
No,
rendered
not 8/8/2016.
8 rendered declaring the petitioner to be a foreigner being aggrieved with the petition will be instituted in the writ proceeding. The petitioner relies on the voters list of 1966 of village Bangalpara, police station Hajo in the Kamrup district, which contains a name of Azahar Ali, son of Jabbar, at serial 187, and that of Tasikon Nesa, wife of Azahar, at serial 188. And both are shown to be residing in the same house number 48. Petitioner also relies upon the voters list of village Bangalpara of the year
1989.
1989, which contains the names of Tasirun Nesa, wife of Azahar Ali, and that of Noor Islam, son of Azahar Ali, at serial number 40 and 43 respectively, comma, where both are shown to be residing in the same house number 13. It is claimed that Azahar Ali is the father of the petitioner and Tasirun Nesa is the mother, and Noor Islam is her brother. Petitioner intends to examine Noor Islam as a witness in the proceeding to render evidence that the petitioner Azufa Khatun is the daughter of Azahar Ali of village Bangalpara. In view of the above, remanded back to the tribunal to allow the petitioner to examine Noor Islam, son of Azahar Ali, of the voters list of 1997 of village Bangalpara, the respondents in the Home Department may cross-examine the said witness and also make their own verification. And thereafter submit report before the tribunal. Upon the needful being done, a reason order be passed.
She can bring in more materials because all the
Petitioner
photos-
may bring any further material if so advised.
the
17.
What is Ramjai Viswas?
Ranjay.
Ramjai Viswas. Who is the father of Ramjai Viswas?
Rajani Lordship.
Page number.
Page number Lordship. Initial is the migration. Page 24 Lordship.
Can you read it?
Yes, Ranjay Namasudra, son of late Mahesh Chandra Namasudra, arrived at the. From original is there in the record, Lordship.
Can you read it?
Name I can read.
No, we cannot read anything.
Original.
So
there-
why are you retaining the better copy for yourself and giving us a copy which can never be read?
Original copy is there in the record. Type copy is there also.
Speak.
I can understand. It's
This is
very
a-
old document.
This is expected to be read. I don't know. This
I have. the
page number
type-
24, this is expected to
23
be
is the
read.
type copy of Lordship. And I have the original in the record.
He is the father.
Father and 71 he has casted vote Lordship and he has applied.
How did you translate it? Type it out if you cannot read.
Here I can read Lordship certified copy which I have obtained from the learned tribunal.
Therefore, we are saying we are retaining a better copy for you and giving us the copy which
This is
can
the
never.
original certified copy which I have.
I understand. While preparing the copies, one copy is filed for us. Another
I
copy is filed
apologize
for
that, Lordship.
His Lordship. And the third copy is written by you for your purpose. The third one is readable, but the first and the second one is not readable. And you expect us to read that.
I apologize for that, Lordship. Original one is there in the record, lower court record.
Anyway, the Rajani Namasudra. Colleagues. Heavy corrosion, Matok Tang Poriujo. Call that man again. And ask us him to read it for us. Let him do it. Undertake that. Readable, no, nothing is there. Just take up. And let the menu pass. Come and read it. Marginally better into. Let him read. Very pare. Because by. So this Rajani Namasudra is the father. Which document will show?
And father also casted.
No, which document will show that Rajani Namasudra is the father?
20, page 28, voters list.
28. Isn't it here? 28. No, we are not asking you for this copy. We are trying to ask the registry people why they are accepting it at all first place.
It was typed.
That maybe. Hmm. His 23 was complete black. His 26 is complete white.
File for the certificate copy.
We understand. What happens is when the original is not good, you make one photocopy. From that photocopy, you make another one. Then you make the third one. Then you make the fourth one. By the time you make the fourth one, either it becomes complete white or it becomes complete black. And this must have happened. Anyway, which page you referred?
Lordship.
Rosani, this
1985 lordship.
85, Rosani.
Yes, lordship.
This is of which village? Ozari. And this relief certificate, does it refer to Ozari?
71 also. in order.
Page number?
Page number lordship again is 5. Page 26. Type copy is at page 25 lordship. And he has applied for the certified copy, but before the judgment, he did not receive that. When the opinion was passed, before that, he did not.
So this is Rosani,
Rajani is the father.
in village Ozari, this part. What did you know? Heard MSD Ghosh Land Council for the petitioner also. Send it back. The petitioner, what, Ramjai Biswas was referred to the foreigners tribunal number,
1 Kamrup Metro.
foreign tribunal number 1 Kamrup Metro. For rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number 10489/2011. Ten 10,000 cases registered in one tribunal in 1 year.
From IMC, all the cases were there, because at that time it was one tribunal. Initially, it was one tribunal.
The tribunal rendered an opinion dated 24/7/2017 declaring the petitioner to be a foreigner, being aggrieved the said petition is instituted. In the writ proceeding, the petitioner relies upon a refugee arrival coupon issued by the Rehabilitation Department of the Government of Tripura, which contains the information that Rajani Namasudra, son of L. Mahesh Chandra Namasudra, had entered the state of Tripura from East Pakistan on 7/6/1964. It is stated that thereafter Rajani Biswas, son of Mahesh, settled in village Ozari Dimoria in the Kamrup Metro District.
Yes, Lordship.
In the Kamrup Metro District. And accordingly, his name appears in the voters list of 1971 of village Ozari Dimoria at serial number 457. Reliance is also placed upon the voters list of 1985 of village Ozari, which contains the name of Rajani Biswas, son of Mahesh at serial 161, and that of Ranjai Biswas, son of Rajani at serial 162. And both are shown to be residing in the same house number 129. Accordingly, it is claimed that the burden under Section 9 of the Foreigners Act 1946 has been discharged, inasmuch as the name of Rajani Biswas appears in the voters list of 1971 of village Ozari, and the name of Ranjai Biswas appears along with Rajani Biswas in the voters list of 1985, also of village Ozari. It is established that Ranjai Biswas, being the son of Rajani Biswas, is also a citizen of India. Further, the antecedents of Rajani Biswas can also be established from the rehabilitation certificate, from the refugee rehabilitation certificate. you're remanded back to examine the refugee rehabilitation certificate as well as the voters list of 1971 and 1985 of village Ozari and pass a reason order. Petitioner may also produce all the intervening voters list of village Ozari for examination of the tribunal. May make their verification. Submit a report.
Item 18,
আহিলে এখন পঢ়িব দিব। Just ask that person to read it. Right, copy. Does it mean you can give any kind of document? No, that is so. That the eligible copy can be passed even if it is supported by a bad copy.
Let's see. Total list actually find that is.
Hmm.
6.
18, Badaruddin. Who is the father?
My lord, Shikimali is his father
Hmm.
in 26. Yes,
26. 26.
20.
Sikkim Ali.
Shikimali is father, my lord. Zara Khatun is mother, Simali is brother.
And who is the mother? Hozara.
Zara.
Hozara mother.
He
60.
says that
Khoramara.
Basiruddin recorded at serial number 71. He is the Basiruddin. The name is wrongly recorded.
Sikkim Ali, Hozara Khatun mother. Yes. Which document also Sikkim is the father?
My lord, at this Buddha list, my lord, one name Basiruddin recorded, my lord. My lord, he said that Basiruddin is his name wrongly recorded as Basiruddin. In both these 66 and
Petitioner Badaruddin
Basiruddin,
claims that he is actually
my lord, actually
the person
Basiruddin, but
Basiruddin of that 66 voters list.
his name is wrongly recorded in the Buddha list 66, both 66 and 7 as Basiruddin. My lord, correctly recorded, my lord, in 85 Buddha list. Lord, you will find it
66 Khoramara 70. Where is 70?
70, Lord, you will find in place 20.
7.
My lord,
No, just a minute. And in
85
Khoramara
Buddha list,
to
Lord, you will find
Badaruddin.
as page 29.
Basiruddin. Do we have the 85 voters list? 85?
Yes,
85.
at page
also.
29.
Okay.
Badaruddin. Here his name is, according to him, name is correctly written in this Buddha list.
What about why Hamid Ali name is not there in
That
1970?
is, that is not explained in the WSCB. That's
Hmm. In fact, one Hassan Ali is there.
personally,
Hussein Ali or Hussein Ali. Here
maybe
it
my
is.
wrong recording of.
So is Hassan Ali and Hamid Ali same person?
Maybe same person. Ahmed Ali is the correct name.
Mistake or the same.
No, there are two mistakes.
That's what I think.
Had Hassan Ali's name also appeared in 85, we are thinking of allowing a petition right here.
Because your lordship, the name, both names is, and they have been in one Hassan Ali and one.
No, but the village is Ghoramara Part 2. Everything is there.
Others.
That obtain the lordship complete voter list, lordship.
Sikkim also. And as per 66 and 70 voters list, Hassan Ali is the son of Sikkim.
Sikkim, your lordship.
Hozara Khatun is the wife of Sikkim.
Yes, sir. Name-
85 Hozara is also not there.
Yes, sir.
Hassan is also not there. It becomes Hamid.
Hamid.
And Bosiruddin becomes Bodor.
The Sikkim name is similar. Sikkim is there. lordship.
Suppose there are two Sikkim in the
Yes,
village.
Rest everything has changed, only Sikkim.
There is no assurance that two persons named Sikkim did not exist in the same village. The respondents in the election commission may produce the complete voters list of 1966, 1970 and 1985 of village Ghoramara Part 2. In order to enable the court to examine as to whether Bosiruddin, son of Sikkim Ali, of the voters list of 1966 and Bodoruddin, son of Sikkim, of the voters list of 1985 of the same village are one and the same person. Next week, 2 weeks.
19.
Yeah, if the information is correct, we'll finish the matter here only. It need not even go back also. Oh, you're sure. You go. এখন পড়ো।
Extra copy আছে নাকি? এইটো আব্দুল জলিল। আব্দুল জলিল বেলেগ নাকি? আব্দুল সামাদ। এইটো আব্দুল জলিল। আব্দুল জলিল নামটো আছে নেকি? 19 এই জলিল নাম। 19 তো আপনার। এক্সট্রা কপি আছে? চেক করি যদি আছে ডিটেকটিভ চালাই দেবো আৰু এটা বস্তু কৰিব আধাৰ কৰিব পৰা তেওঁলোকে কি কৰিব
in view of that, they say that, no, they say that they are giving a type copy. Type copy village is the first one. So, our type copy, they can not go, but it will go. It won't be for you. Type copy is very good. Type copy, ধরো অন্য এখন দেখুন যে অমুক মানুষজন টাইপ করতে বিক্রি হতে পারে কোনটি কোনটি বলতে টাইপ করা কেন করি মানে ইন্টারেস্ট থাকে
Item 19.
His lordship, his father's name appeared in 1966 and 1970.
Is your microphone off? Just please check up.
Yes, microphone too.
Lordship, a petitioner's father's name appeared in 1966-70 and remaining brutalist lordship. But petitioner's name does not appear with his father along with lordship.
Does not appear along with father. That means he must not,
Only
then he is not the son, that's why it does not appear.
only can the page in 35 lordship,
Page 35.
35. A Jalil Mia, petitioner lordship.
A. Jalil,
Jalil.
son of Noyan Ali, he is,
Is my father lordship.
Noyan Ali is the father.
Father in page 1960 brutal list 31 page lordship.
Noyan Ali was alive at that
No.
point of time.
At that time, now he is not a-
Noyan Ali, son of Gonjir.
Gonjir.
Just a minute.
In fact,
House number 29.
I separated from my father's family, and accordingly, my name has not enlisted with my father lordship. Apart from that,
1985 voter list is of different village.
Different village.
1985 voter
One
list.
is Banglapara.
Banglapara is my village lordship.
No, 70 is Banglapara. 85 is also Banglapara.
No lordship.
Page 30.
Page 33 lordship. Guna Binna.
Page 33 is Gona Bina, but page 34 is Banglapara again. Both are 85.
Yes.
I separate from my father's family lordship.
Your father's family separated from you because you are in the same village.
Yes, lordship.
Father must have gone away somewhere.
Jamabundi also there lordship. I
Jamabandi.
along with my father's name.
Page
appears
num-
in
page number?
Jamabundi page lordship, page 20.
Abdul Jalil, I am son of Noyan Ali, Shahabuddin, Shaheb Ali. His DW true lordship. It is my family lordship.
This is again of a third village.
Lordship.
This is again of a third village, Nomborpara.
That our land there is my our
Mr.
land.
Suleiman, a casual statement, our land, this, it happens, will not serve your purpose. You prove it, that all the people are the same person.
Yes, that located our land is available, lordship. Apart from that, my school
Mr.
certificate.
Suleiman, you are not sitting in a drawing room across somebody and just casually saying something. You are in a court of law. Once you make a statement that although the name of the persons are same and the villages are different, you'll also have to prove with material that they are the same person.
Lordship.
If the equation arises, Mr. Suleiman of Calcutta and Mr. Suleiman of Delhi, and another person sitting in Madras will say, both are same person. Will it serve the purpose? It may be same, it may not be same. Both are equally possible.
Bangladesh village page 30 lordship, school certificate. They record my name, village is Banglapara.
Where is the school? So now, why don't you produce a best document? Why are you referring to your
Page 30.
page 3?
30.
30. This is again Chokla Higher Secondary School, post office Chokla Bhaya Manipur, Bongaigaon.
Lordship.
This is again the fourth place now.
My district.
Village Banglapara. Have you examined the school headmaster?
Lordship.
Hmm?
Abdul Jalil. Village Banglapara.
Did you examine the school headmaster?
Lordship. No, lordship.
Then certificate has no value.
Not examined.
Where is Madam Decca gone? Yeah, give this order, you did not call her. The district elementary education Bongaigaon to collect the admission register in original of Chokla Higher Secondary School pertaining to the entries of the year 1964 and prior, which may contain the information that Abdul Jalil is the son of Noyan Ali Mia of village Banglapara. A copy of this. Prior to 1964, particularly of serial number 610/62 dated 25/2/1962. Origin of the admission register. A copy of this order be made available to MSB Decca, Land Council for the Education Department. List after.
Item 20.
If you have examination for a daughter, you examine the school registration. No, school registration. Syed Ali.
May I please your lordship? Petitioner himself has casted vote in the year 1971,
Page number.
page 57, lordship.
His name is what is Syed, na?
Saifal.
Saifal Ali.
His wife and his
Where is the notice, tribunal notice?
tribunal notice I have not annexed, but thereafter he has shifted lordship. From 97. To Kannada bill.
No, notice is to Saifal Ali of Kannada bill, or notice is to
Yes.
Saifal Ali of,
No, Saiful Ali of Kannada bill.
Ah.
Because I have
how
not
you
annexed
prove
the.
your shifting?
Notice, no, Gao is not Kannada bill, it's Bamun Turi. Gao is Bamun Turi.
How you prove it?
Lordship here, he, in this case, he has, I have annexed the order sheet lordship. He had prayed thrice for further evidence. And thereafter, it was rejected on the last occasion and thereafter. So my humble submission is, if he is allowed,
No, where is that impute order?
impugn order is at page lordship 34. But order sheet I have annexed subsequently.
You say a final order.
Yes, lordship.
So if
He
you-
intended to
Sorry.
adduce more evidence if we see the order sheet lordship. And even his documents also he has not.
You ought to have filed a writ petition against those order when the matter was pending.
Yes, lordship. They came, once he was declared foreigner, he has approached us.
Hmm. So you produce materials before us, we'll examine. If they are relevant, we'll send it back.
He himself, my materials which I have annexed lordship, is the voters list of 1966 of his mother.
We have read,
Subsequent 71, he himself has casted vote. And thereafter,
So-
lordship,
we are on Saifal, son of Torak of village, what?
Kannada bill.
No. Page 57 is Ma something. Mathar something.
Matadanga.
But notices of not Mathadanga. That is of, he is in 71, he casted vote from that village. Mathadanga not
Ghosh,
there. Yes,
If you
lord.
can prove that you are that man, then you have discharged your burden. So this is Saifal of Matharbhanga village.
Yes, lordship.
Now you say that later on in 97, they shifted to village some Kannada something,
Kannada bill.
Kannada bill.
Yes, lordship.
So now your name will appear in Kannada bill.
Yes, lordship.
So you have to show that both persons are the same person.
Yes,
So
lord.
now prove your shifting.
So his
The
wife name,
petitioner may produce any.
lordship, subsequent voters list, his wife name is there in 71. She is subsequently there in 2005 also with him in Kannada bill. So their family has shifted.
Does two persons never have the same name of husband and wife both together? It is possible at times. The petitioner may produce any relevant material which may show that the family of Saifal, son of, Saifal, son of Tora of Matharbhanga village had later on shifted to
Kannada bill,
Kannarabil village.
Bamun Puri. Stipulated. 1 week term.
If you want, you can take the help of Mr. Ali, if you want any voters, etc.
Yes, lordship. A week's time, lordship.
Abdul Jalil. Who is this? None appears for the petitioner when the matter is called. List again. Upon further non-appearance, appropriate order shall follow. 22, I think your case, madam, goes.
22.
21, my lord, I'm sorry, I one lakh enter. I am ready.
21 is over, go. We have called 22.
Sorry, one lakh lordship.
No, you please wait for some time. We'll call your matter again. But once the matter is called, next one is called, it's won't be very proper to
Yes,
go back.
yes.
You wait, we'll take up in time. permits. 22.
Yes, Lord.
22 is Afzal Hussain. Who is the father?
Father is Muslim Uddin Lordship, alias Muslim Sheikh. Page 52.
Page number?
52 Lordship, Muslim Sheikh.
Muslim Sheikh, son of Usman.
Yes, Lordship.
Bilasipara Pothar.
Yes, Lordship.
He is the father.
Yes, Lordship.
Which document will show?
Then subsequent voters list is Lordship, 70 of father and mother, same village,
Page number?
page 53 Lordship.
Page number 53.
53 Lordship. And Lordship, 89 voters list of the same village.
Father, and who is the mother? Koriman.
Yes, Lordship, Koriman Nessa.
Then next page.
Next is his voters list, Lordship, page 56,
Hmm.
same village.
Hmm.
Not same village, Lordship.
Not
Not
same
same
village.
village.
Had it been same
Bilasipara-
village, matter would have ended here only.
Hekia Jani Patha. No, not same village, Lordship. It's
Gun
Hekia.
mother, Dhekial Joni Pothar. Pothar is same, but one is Dhekial Joni Pothar and the other is
Other
Bilasipara Pothar.
Patha. Yes, Lordship.
Two village name is checked here. Lordship.
Adjourned on the prayer of.
The Jamabandi is there, Lordship.
Hmm?
Jamabandi is at page 64. Muslim Uddin,
Page number 64.
Muslim
64 কোনখন এইখন?
Uddin.
This is a land in which village?
Bhikiajan Pathar, most probably.
Again,
Another
Dhekiajan.
different-
Thekia Jani Pathar, where where 89 voters list is there, same village. It's of
Adjourned on the
58,
prayer of the land
59.
council for the petitioner to examine as to what material is available.
This
that-
is linkage is same village,
No.
89, and this is of 68, 69, same village.
Then you cannot rely on the Bilasipara Pothar. So you formulate your argument first.
Yes, Lordship.
If you are relying on the name of the father in Bilasipara Pothar of 1966
Yes, Lordship.
and a man of same name in Dhekiajani Pothar through the Jamabandi, both are not the same person. But you started with Bilasipara Pothar.
Yes, they have, in that area, they have.
So you
land.
think about it, how you want to present it. Yes. I want to be listed.
23.
Lordship, here the petitioner has filed the evidence, but the cross was not done, Lordship. If my humble.
Cross
submit-
of whom? DW1.
1 and 2, Lordship.
Who are they?
One is the petitioner and second is the father of the petitioner. Moreover, Lordship, on 10/12/21, Lordship, he filed his counsel filed a petition that his mother died recently. So he couldn't appear before the honorable.
It's a ex parte order.
Yes, Lordship. Not expert, but
What?
cross was not done. Lordship.
Cross was not.
Yes.
Third damage, H. Betalan, counsel for the petitioner also have. The petitioner Jilmon Ali had been referred to the Foreigners Tribunal number
3,
3,
Kamrup Metro.
Kamrup Metro, for rendering opinion as to whether he is the person who entered the state of Assam on or after 25/3/1971. The tribunal rendered an opinion dated
21 to 2022.
20
January 2020.
21/2022.
Yes,
21/2022. 21 21/2022. Rendering an opinion that the petitioner is a foreigner, being agreed, this petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of
1970, Lordship.
1970 of
Village Kholar Bandha.
Kholar Bandha
Yes, Lordship. Page
police
78.
station.
Tarabadi, Lordship.
Police station, Taravali. In which district?
Barpeta. Kholar Bandha.
Taravali, in which district?
Is Barpeta, Lordship.
In Barpeta
Yes.
district, which contains the name of
Makmul,
Mahmul,
yes, the father of the petitioner,
no, Mahmul, son of
son of Sonet.
Sonet.
Yes,
Mahmul, son of Sonet, and serial number
serial number 670, Lordship.
at serial 670, and claims that Mahmul is the father of the petitioner. To substantiate the same, the petitioner had examined herself or himself. This is a man or a
Man, Lordship.
man. He had examined himself as DW1
Yes, Lord.
and
DW2 is the father.
Mahmul as DW2.
Yes, Lord.
But it is stated that the respondents in the Home Department had not cross-examined the two witnesses. It is circumstance matter remanded back to the tribunal to enable the Home Department of the Government of Assam to cross-examine DW1 and 2.
The Lordship, additional documents, if I may be allowed to.
And most of the respondents in Home Day may also make their own verification, submit report before the tribunal. The petitioner also allowed to adduce any further evidence as may be applicable. Upon doing the needful, reason order be passed.
Much.
Petitioner also to produce the complete voters list of the procedures.
Much.
For orders, item 24.
That is hearing. I think we gave some interim order on the last occasion, or it was not given,
Interim, my lord.
but of no
perhaps
use.
Not help me because the new
That's why
employer.
I
is
said
not a native
interim
party.
order of no use.
Absolutely no use, my lord.
What kind of interim order was given?
The status quo was passed perhaps
Hmm.
in one
So
occasion.
why it is not effective?
Because they are not, the new employer is not a party here, my lord. We are on a review petition. my lord. After my dismissal, I was employed somewhere else.
Hmm.
Now, they have initially issued an explanation letter to me,
Who?
my lord, my new employer,
Your new employee? No, this is dismissal.
my lord,
Dismissal by the old employer.
my lord.
What have you challenged in these proceedings?
My dismissal order, my lord.
Dismissal order.
My dismissal.
That is between you and your old employer.
My lord.
Now you are employed somewhere else.
Some lord.
If you happen to succeed, you'll get back your old employment.
My lord. I'm still there, but I was forced to go on, my lord,
1 month leave without pay.
No, I have not understood. Man is dismissed.
Man,
That is under challenge before this court. If we interfere with the dismissal, he'll be back in employment
man.
with that old employer.
No, I'm not interested in going back to the old employer, madam. My lord, in this my lord, in this my lord review, my only limited prayer, my lord, is to convert this dismissal into that of removal. So that
So
my
that
new-
you can have employment
My
elsewhere.
lord.
That's the only
my
grievance. Yes,
only-
Mr. Mojumdar. What will you gain if this
My lord.
man has no employment and he'll starve?
My lord,
Because
factually,
I know he must have done the worst of the act while under your employment. You don't want him in any manner. You also don't want to see his face also in future. That also we understand. If this man survives by getting an employment elsewhere, how does it materially affect you in any manner?
should not, my lord. Normally should not. Only thing is, my lord, he
Huh.
will be.
So why don't you convert it to that of a removal? If some new employer is happy with this kind of a person,
My lord, he is already employed.
Mr. Mojumdar, but your order of dismissal will affect his new employment because as the law is, we understand,
Re-employment.
a dismissal will prohibit any further employment of the same person.
My lord.
Whereas a removal will enable him to be employed elsewhere. But the effect is same, the employer-employee relation is severed under both circumstances. You want a severance of the relation as your employee. He is accepting it.
My lord.
But the order of dismissal will disable him to have any further employment anywhere else.
My lord, I have understood.
Huh.
I have what
Now
I-
let us convert it to a removal because you don't lose anything.
Right.
He's not going to bother you anymore. He's already gone. Let his family survive. If somebody else wants his employment, let them have it.
In fact,
And if he can get employed somewhere, let him have it.
on the last occasion, your lordship directed to bring instruction, what the authority, well, they have given a written instruction.
No, otherwise, we don't see any reason.
Well, they said they will consider if they file, he files a representation, they will
No,
consider.
he is already a severed employee. How can you file a representation?
No, for conversion.
How can you file it? Then we have to recall all the orders approving your dismissal. If you want to retain the jurisdiction to take this decision, that means we have to interfere with the order of dismissal, bring it the status quo ante back. Then we'll make an application that what kind of punishment you want to give me now. You take your decision. Only then you'll have a jurisdiction. Otherwise, from where would the old employer exercise his jurisdiction?
Authority, yes. They have become functus officio.
We use a discretionary power. What was the charge?
my lord,
Misconduct.
What was the misconduct?
He had to attain 5 training program. He was employed in a discipline force, my lord, APRO, Assam Police Radio Organization.
Very well.
Sub-inspector. Out of 5, he attended possibly 3.
3.
Thereafter,
Was it a misconduct of such moral turpitude or such an act
I'm not
which will make the person ineligible for employment anywhere?
normally not, my dear, that is correct. My lord. What I'm saying is, my lord,
So let us reduce it to removal.
I leave it to lordship, my lord. Because only one thing, this should not be a precedent, because others will say that we are also guilty of
No,
misconduct.
we'll give a reason that the alleged misconduct does not involve any serious moral turpitude. It does not involve any such act which renders a person to be ineligible for employment anywhere else. It may only entail that the employer had lost confidence in this person. So you don't want to retain him in your employment. Very well, Good reading. And as removal will serve your purpose, we reduce it to that by removal.
And leave it to Lord.
And you also don't go and bother your old employer anymore.
Not at all.
Be happy with your new employer.
Absolutely,
So
not at all.
He are already bothered. Now he cannot bother anymore.
No, from now onwards, you'll not bother. So you're also happy.
Because I'm told that I must indicate to some report. Out of 5, he attended 3, therefore he did not attend. Then the same proceeding was drawn up. There also he.
Mr. Mojumdar, we understand it may be a misconduct. But what we are saying
Well,
that
that's why I said I
dismissal
leave
will
it to
be
Lord.
disproportionate from the nature of the misconduct alleged, in as much as. So suppose for the next question I usually put,
It's not a huge
no,
misconduct.
not that. Suppose it is proportionate to dismiss him now
Yes.
for this misconduct. It's the highest punishment. Suppose the misconduct would have been 10 times more severe and serious than this one.
What punishment?
What would they have done it? Would they have
Under
hanged
the
him?
rules, there is nothing
Would he
more
have-
than this.
Then next would you ought to have hanged that person then.
Exactly.
If you go by proportion.
I'll leave it to Lord.
If you go strictly by proportion, maybe you would have asked to also ask you a question. Why a censure or warning would not have been sufficient for this man?
That's why I leave it to Lord.
If you go strictly by proportion, it's more commensurate with some kind of a warning that don't or that withholding of increment or all those kind of, there are 7 or 8 punishments there under the rules.
I'll leave it to Lord. Let him have his new job. He has got a job. Let him be happy.
We'll pass the order.
Because he has already got the job. He should
Mhm.
use it.
You have to just give us some more information, what job you were doing at present. Those details you give it to the courtmaster.
My lord, he has got the job of a
My lord, presently I'm serving as a deputy registrar in Concordia
deemed university.
University.
If it is converted to. My lord, if it is converted to.
And if you have difficulty in passing the order, we'll get it listed again day after tomorrow.
Man, much, much,
If we need some more facts.
much.
Yes.
May please, your lordship. My lord, page 27, 66 voter list of village Topgaon.
Page 27.
Bhandakular at page 28. Father's name is Mofisuddin.
Father is Mofizuddin
Mofisuddin.
and mother is Alima.
Ali. My lord, 70 voter list, only one person is certificate contains only one person, father.
It's okay. Now,
My lord,
which document will show that Abdul Samad is the son of Mofizuddin?
my lord, 85 voter list at page 37.
Page 37.
Father's name is missing only, against his name, father's name is shown Mofisuddin. my lord.
Hmm.
Father's
Just a minute. Page 37.
31, my lord,
31.
31. My lord, all
31.
along,
Samad Ali,
yes. Samad Ali.
Mofizuddin. So what is the difficulty?
Father's name is not in the same column. my lord.
Sorry.
Father's name, father has expired, my lord. Against his name, father's name is shown. my lord.
Against who is the
Samad Ali.
petitioner? Samad Ali.
Samad Ali.
And who is the father?
Mofisuddin, my lord. Against his name.
Mofizuddin.
Against
So page 31.
31.
It's okay. Samad Ali, son of Mofizuddin.
my lord. And Mofisuddin is voter in 1966.
No, that we have already read.
70.
Heard Mr. A.S. Sigdal and counsel for the petitioner also heard. So Abdul Samad had been referred to the Foreigners Tribunal number 2, Bongaigaon at Ohayapuri for rendering an opinion as to whether he is a person who entered the state of Assam from the specified territory on or after 25/3/1971. The tribunal rendered an opinion dated 9/9/2016 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1966 of village Topgaon Part 2. Under Ohayapuri SC LSC 42, which contains the name of Mofizuddin, son of Taleb Hussain, at serial 40, and that of Alima Bewa, wife of Alima Bewa. Alima Bewa is the wife of Talib Hussain.
Mother of Mofisuddin.
A wife of Talib Hussain at serial 41. It is stated that Mofizuddin is the father and Alima Bewa is the grandmother of the petitioner. The petitioner relies upon the voters list of 1985 of village Topgaon Part 2, which contains the name of Samad Ali, son of Mofizuddin at serial 266. Accordingly, it is claimed that the burden under Section 9 of the Foreigners Act 1946 had been discharged inasmuch as if Samad Ali is son of Mofizuddin in the voters list of 1985 of village Topgaon Part 2, and Mofizuddin is the son of Taleb Hussain in the voters list of 1966 of village Topgaon Part 2, comma, it has been established that a petition is remanded back to examine the voters list of and pass a reason order. Respondents may make their verification, submit report. petitioner to produce the complete voters list from 1966 to 1985 of village of Gaon Part 2.
Develop Rangers.
26.
Kindly pass it for time being.
My lord, 27, my lord, some time may be given. We will
Adjourn
propose
on the
some-
prayer, Mr. A. Sigdal and counsel for the petitioner.
Develop.
28 years.
28.
Hmm.
Page 21, lordship. Connection.
Who is the father?
Father is Osimuddin. And mother is
Osimuddin father,
Suburjan is
Suburjan mother.
mother.
Which document will show Osimuddin is the father?
One Gabra certificate and one person from that village was,
Gambura certificate.
the Gabra was not examined. But some more time
One person from the village.
of that village. was-
Which page?
Village में two non Sasra and page 43 lordship.
Page 43.
Is it about 68 years ago?
DW2, Alauddin.
Allowed him. He was duly cross-examined.
Yes.
No other documents,
Uh,
no other document is linked to his father.
But how do you know who this person is? I have come to adduce evidence in favor of Sukur Ali that he is an Indian citizen. This line does not help you. He was born at village Sesara. After Sukur Ali was born, his father shifted to
Monokusha.
Monukosha, along with his two sons, and sold the land at Sesara. To this extent, it is okay. But how do you know that this Sukur Ali and that they are same person? Hmm.
Kind of page 25.
You will do.
Page 20.
Hmm. Yes.
Page 25.
Yes.
Total list of 1993 of village Hajipara Hospital. Here name is Sukur Mahmud.
Page 25.
And reference is against of village Hajipara, but document relies,
Page 25, Sukur Mahmud.
yes, village Hajipara.
This is of some another village, the new village, I think.
I reference that
Hmm.
Shifted to that village as per the written statement.
The petitioner may produce any evidence material which may show that that Osimuddin, son of Nagarali, or his family, Nagarali, whose name appears in the 1966 voters list of village Sosra, had subsequently shifted to village
Hajipara,
Khasipara.
Hajipara.
Khasipara. List after a week. Prove the shifting.
29.
May it please your lordship. Lord, in this case, the imperial order is my lord 18/9/2017. It is in page Page 10, starts from page 10. also. Well, the relevant portion is in paragraph 7, my lord. The name of the grandfather is, my lord, different. First name is same, my lord, Tahez. And somewhere in voter list, it is recorded as Tahezuddin Munshi, somewhere it is Tahezuddin Sheikh, and somewhere it is written as Tahezuddin Ali. Tahez is same, my lord. Only surname is different. And the court, my lord, observed that is not believable.
Is there only one man in this world named Tahez? So that whether he is Ali or Rahman or the other name Munshi, it is the same person.
Village is same, my lord, and everything is same, my lord.
So is there only one name Tahez in the entire village? Village also must be containing number of Tahez there.
Since 1966, her grandfather is a voter, my lord.
66 grandfather, which page?
My lord, 66 is page 15, my lord, type copy,
Page 15.
page 15. 66, my lord. Tahezuddin Sheikh.
Tahezuddin Sheikh is the grandfather.
Grandfather.
Village is Koladanga.
Yes,
Post office Lakshipur. Yes, now who is the father?
father is my lord, Haren,
Or Haran Ali.
Haran Ali. Somewhere it is, my lord, recorded as Haban Ali and Harun Ali.
1975 Koladanga Haran father. So his grandfather. Now, which document will show that he is the son of Haran? Son of Rasia, daughter of Haran?
My lord, voter list of 75, my lord.
75 voters list shows name of
Page
Haran and
19.
Tahezuddin together.
Yes, my lord.
Which document will show that the petitioner is the daughter of Haran?
My lord, yes. Page 27.
Is 27.
Let's follow her price.
They have shifted to, later on they have shifted to my lord, Hotel.
Petitioner may prove that the family of Haran Ali, whose name appeared in the voter list of 1975 of village Koladonga, had later on shifted to village Polahortari. Best after review.
Item 30.
You show the proof of shifting.
And then I will be given 2 weeks time, my lord.
2 weeks, okay.
Because
2
it
weeks.
is a legal aid, my lord, I have to.
2 weeks, okay. Nur Bhanu Khatun, father of Nur Bhanu Khatun,
Yes, I have given my lord.
page number.
Hassan Mikir, Hassan Fakir,
Mhm. Who is the father of Nur Bhanu Khatun?
Hassan Fakir, my lord.
Page number,
Oh, I'm Moinuddin,
page number
page number 18, my lord.
15.
17 is type copy,
18 is some certificate. Where does his name appear?
my lord.
Certified at Khoimuddin. Who is the father? Khoimuddin. Name of the father.
Moinuddin. No, or also will see page 14, the notice.
No, no, we
No,
don't
no,
know.
I'm giving the affidavit, my lord.
We don't want a notice.
No, no,
1970 voters list, page 18. Hassan Fakir. Who is Hassan Fakir?
no, I am telling you. Your lordship may see page 14, there in the affidavit of the I have given Nur Banu Khatun, alias Nurjanu Khatun,
Mr.
daughter
Sharia,
of Khaimuddin.
we are adopting it the simplest of possible procedure. The procedure is Nur Bhanu. We want to know who is the father of Nur Bhanu and where does his name appear. there is a document at page 18, voters list of 1970,
My lord,
containing the name of Hassan Fakir, Rohiman Nessa, and Khoimuddin.
Khoimuddin.
Now, who is the father? Khoimuddin.
Khoimuddin is the father. and
Which
Hassan is
document will show that Khoimuddin is the father? Which document will show that Khoimuddin is the father of Nur Bhanu? Hmm. 18 from original, 17 from the English translation. It's not one side.
I have given my lord the witnesses only, my lord.
Hmm.
Witnesses,
Witness,
my lord.
DW,
DW 27 page.
page number
27.
27. Page 27, just a minute,
Imam Ali.
27. Iman Ali.
Yes, my lord. He is a
Iman Ali,
neighbor.
son of Kurban Ali of village Soisima.
His neighbor and related sister. Which is of the same village. my lord.
Don't you have any Kabinnama, any school certificate?
That
Which may
School,
contain,
no, see-
who is the father of Nur Bhanu?
I know that no. That I have to verify them.
The petitioner may produce any relevant document or material which may indicate that Khoimuddin, son of Hassan of the 1970 voters list of village Soisimona, is her father. Documents like school certificate,
My lord.
Kabinnama, or anywhere where both the names appear together.
My lord. I'll see.
I think that will be much easier for you.
After 2 weeks.
List after 2 weeks.
My-
Item 24.
The order to which it is, okay. Third. And Nath and counsel for the petitioner also heard. So and so. This review petition is instituted against order, judgment and order dated 3/8/2018, rendered in writ appeal 355/2017. Writ appeal 355/2017 was instituted against the judgment and order dated blank Rakhasun 3561/26 WPC 3561/2016. So BBC judgment order to litigation your against the appeal it will defend but it's obligation. No, writ appeal to some date to by maybe. No, full stop. The WPC 3561/2016 was instituted being agreed by the order dated 35/2016 of the I think 9/6/27. WBC 3561/2016 was instituted against the order dated 25/5/2016, by which the petitioner, who was serving as a sub-inspector of police, bracket wireless technician in the Assam Police Radio Organization, was dismissed from service. A disciplinary proceeding was initiated against the petitioner. On an alleged misconduct that he had failed to qualify, that he had failed to undergo certain mandatory trainings to successfully complete and pass the grade 3 and grade 2 police wireless technician grade 3 courses of 9 months and 6 months duration respectively. While the petitioner was in service between the period 2000, between the period while the petitioner was in service, he was called on 7 occasions to undergo the grade 3 training at the APRO training school at Dalubari. But during the period, that is from 2006 to 2013, he had failed to undergo the training by remaining absent. In the resultant departmental proceeding, an inquiry was conducted in which an inquiry report dated 3/4/2016 was submitted. and the disciplinary authority, upon accepting the conclusions arrived at in the inquiry report, had deemed it appropriate to dismiss the petitioner from service. In the WA WA 5/2017, the appellate court examined the procedure adopted by the disciplinary authority, and by taking note of the provisions of law applicable in respect of the procedure to be adopted in a disciplinary proceeding, arrived at his conclusion that as no procedural aberration was noticed, therefore, the order of the learned single judge dated so and so in WC does not require any interference. Accordingly, the writ appeal was dismissed. The result thereof was that the order of dismissal against the petitioner by the order dated 25/5/2016 of the disciplinary authority had attained its finality. In the meantime, the petitioner had been offered and is under employment. As per the order dated 11/7/2017, of the registrar of Mahapuruha Srimanta Hankardev Vishwavidyalaya as an assistant registrar administration. Subsequently, by another order dated 7/4/2021 of the registrar of Mahapuruha Srimanta Hankardeva Vishwavidyalaya, the petitioner was appointed as deputy registrar administration. This review petition is instituted on the premises that the writ appellate court had not gone into the question as regards the proportionality of the punishment that was meted to the petitioner against the aforesaid misconduct, proportionality of punishment meted to the petitioner against the aforesaid misconduct. The circumstance under which the review petition is instituted is explained by the petitioner that as he is under employment under the Mahapuruha University, there is a possibility that if the order of dismissal from service remains, he may be found to be ineligible for any further employment because of the dismissal from service. Accordingly, in the instant review petition, the petitioner intends to raise the issue as regards the proportionality of the punishment meted to him for the alleged misconduct that he had failed to undergo the mandatory departmental trainings as indicated above. Full stop. The mandatory trainings that were required to have been undertaken by the petitioner as indicated above may be a part of the condition of service, without which he may be ineligible to be retained or continue in service any further. From such point of view, the punishment that may be meted to the petitioner for severance of the employer-employee relation with the disciplinary authority may be acceptable. But at the same time, we have noticed that the alleged misconduct is that the petitioner failed to undergo some of the mandatory training during the course of his employment. And although the same may be a misconduct under the law, but it does not appear to be to us to be a misconduct of such serious nature or having imputations of moral turpitude of serious nature or of any such misconduct which may render the petitioner to be ineligible for any further employment in any other organization. As the said aspect was not gone into either by the disciplinary authority or was not appropriately examined in the writ appellate judgment, we are of the view that considering the aspect that the only misconduct of the petitioner is that he had failed to undergo certain departmental examination, the punishment, extreme punishment of dismissal from service would be disproportionate. If the act of the petitioner in not undergoing the required departmental training would be a reason for the authorities not to retain him in service any further, the purpose can also be achieved with a punishment of removal from service, in which circumstance the petitioner would remain eligible for any further employment in any other organization. Considering the matter in its entirety, as well as balancing the equity and also taking note of that the respondent authorities having severed the employer-employee relation with the petitioner would not be adversely affected in any manner. Whereas on the other hand, and then they would be affected in any manner, the impugned order dated 25/5/2016 passed by the imposing the punishment of dismissal from service is interfered to the extent that it shall now be converted to that of a removal from service. Review partly allowed, as indicated above. Thank you. Some dates will be given. How many matters there? I think one is that part of the series also. Series tomorrow. And the parallel series tomorrow. Rest some day. What is your thing?
Lordship, the detention matter, if can be taken up tomorrow,
Which detention?
item 9, Lordship.
Oh.
Item 21 to এটা date দিয়ে দাও।
আরে সবাই গেলে একটু ডিফেন্স একটু ডিটেনশন টু